Good morning. Good morning. Yes, ma'am.
Vince, do you have court this morning? You do.
What time do they need to test the fire alarm?
They need to they're just trying to figure out when they can do it.
Okay, I'll be here all day, so just whenever they need to do it, I'll take a break. Are this going to be an involved process, or
It's probably gonna be about 45 minutes.
are they already
So
here?
They can come back.
No, that's fine. Let me get court launched, and I will go to the house or somewhere.
He said it'd be probably 45 minutes, no longer than an hour, but.
Okay. Let me wait until a little bit after 9. Let me get court launched and people conferring, and then I'll go to the house or something.
Okay.
All right.
Thank you.
All right, ladies and gentlemen, I have about 9 o'clock. I'm going to call the dockets. Let me ask Ms. Riley. I didn't see a name on the Kearns docket, but I assume that's mine.
No, sir, that's going to be with Judge Ellison. All you have is 2 civil cases for Atascosa County, and I believe that's it.
Oh, I don't have the Wilson either.
No, sir.
How did Lynn wind up with her?
All right, it just worked out that way.
San Miguel versus Peeler.
San Miguel's ready, Your Honor.
Others are ready, Your Honor. There are 3 motions pending today.
And how long to hear these?
Our estimate would be 2.5 hours, Judge.
Your Honor, this is Dan Lanfear for Justin Peeler. We have a motion to compel mediation. It'll probably be 5 minutes, I would suspect.
And we agree to have that heard first, Your Honor, since I think the parties are agreed at this point on that motion, and then Mr. Lanfear can step out if he and the court are in agreement on that.
Okay, certainly. All right, Guerrero versus Solis et al.
Your Honor, an agreement has been just reached on that, so go ahead and pass that.
Okay,
Thank you.
all right. Reset on request. Okay, I think Mr. Schick heard because I didn't have my microphone muted. I was stopped by the bailiffs whenever I got here this morning, and the district clerk's office just came in. There's some issues with the automatic firefighting system here in the courtroom building. And they have folks who are working on it and testing it. And that's going to take anywhere from 45 minutes to an hour or more, depending on how things go. So I am going to pack up here. I probably go to the house and get set up there. Let's call it 9:45. Make sure I have plenty of time to get set up, and I will see y'all back at 9:45. And I don't know if I'm going to stay there or not. Okay, but apparently the fire alarm is going to be going off and on while they test it, so I don't figure we could have court in those circumstances. So I'll see y'all shortly. Ms. Riley, I'm going to make you the host because I found out that if I just get cut off or leave in the middle of a meeting, it picks someone at random and makes them host.
That's fine. And Judge, I thought Karnes County was having the grand jury today as well. That's one reason we had some of the cases moved over.
Yes, that's true. Okay. It's been 6 years and almost 3 weeks, and I have, for the first time, not shown up in the right court, in the right county. Well, it was a modest run. Okay, Ms. Riley, I'm going to ask you to call the district clerk's office down there and tell them I'm on my way. And I will excuse everyone else until noon because I've got to get to Karnes County and make my apologies and get the grand jury impaneled. So I will recess this until noon. I'll see y'all then.
Okay.
Thank you, Your Honor.
us going on Zoom again because we have restrictions on people being in the courtroom due to social distancing. We have to have this broadcast over the internet to make sure that anyone who wants to view the court proceedings has an opportunity to do so, even if they can't be here in person. All right, you have been summoned to be here today to serve as in the grand jury for the hopefully January term of the grand jury. I say hopefully January term because typically the grand jury has a 6-month term, but last year due to the COVID situation, they were extended and they had to do a full year. The grand jury determines whether felony criminal charges should be brought against an individual who has been accused of an offense. No person may be made to stand trial for a felony offense unless those accusations have been considered by a grand jury of citizens who reside in that county where the crime is alleged to have been committed, and those citizens determine that there is probable cause to make that person stand trial. You were summoned by the same random proceeding that we use for summoning jurors for a case that determines either liability in a civil case or guilt or innocence. And you said that the grand jury's been meeting every month? It used to be more typical for the grand jury in Karnes County to meet only every other month, but right now you're probably looking at meeting at least for a while every month. Now, meeting every month will, after today, typically mean about once a month you would have to spend one Friday morning up here at the courthouse going through grand jury materials. Grand jury service is an important part of the criminal justice system, and the citizens who serve on the grand jury typically say that they enjoy their grand jury service because it gives them an opportunity to learn about what's going on there here in the community. So I'm going to ask all of the folks on the panel as prospective grand jurors to stand and raise their right hand so I can administer the oath of prospective grand jurors to you. I know that 3 of you have already done that, but I'm going to ask you to just everybody stand up again. Each of you do solemnly swear or affirm that you will true answers make to such questions that may be propounded to you by the court touching upon your service and qualifications as a juror, so help you God. I do? Go ahead. All right, is there anybody who did not take the oath? Okay, and please be seated. Let the record reflect that no one indicated they did not take the oath. Now, I'm going to go over some qualifications with you, and then I'll do it the old way. I'm going to ask you 3 questions that you have to answer. Are you a citizen of this state and county and qualified to vote in Karnes County under the Constitution and laws of Texas? All right, is that yes? Are you able to read and write? Yes. Okay. Have you ever been convicted of a felony? Are you presently under indictment or other legal accusation for theft or for any felony? All right. Now, is there anyone who answered no to the first question, whether you're a citizen of this county, or answered yes to the next 3 questions, answered no to the first 2, whether you're able to read and write, or whether you're a citizen of Karnes County and qualified to vote, or answered yes to the last 2, whether you've ever been convicted of a felony or whether you're under indictment or legal accusation for theft or for any felony. All right, let the record reflect that no one's indicating that they are. Now, I'm going to set those qualifications out in a little bit more detail. I'm going to ask you to listen very carefully to these qualifications. And if you have any question in your mind about whether or not you're eligible to serve on the grand jury, in just a moment, I'm going to ask folks to come up one at a time so I can discuss that with them, because we have to make sure that everyone who serves on the grand jury is legally qualified to do so. Again, you must be a citizen of Texas and of Karnes County and qualified to vote here in Karnes County under the Constitution and the laws. The fact that you haven't registered to vote does not disqualify you. You just must be able to register to vote. That requires 2 things. You must be a United States citizen and a resident of Karnes County. If you are not a United States citizen or you're not a resident of Karnes County, you're disqualified. You must also be of sound mind and good moral character. You must be able to read and write. You must not have been convicted of a misdemeanor theft or a felony. All right, so if there is any conviction in your background, for instance, theft by check or shoplifting, or any felony, you are disqualified. But there is also, confusingly in Texas, a offense of issuance of a bad check, which does not disqualify you. So if you have any of those things on your record, I need to ask you to come up in a moment so we can discuss them. Also, an adjudication as having engaged in delinquent conduct for a felony as a juvenile would disqualify you, all right? And I said convicted. We have, of course, the old suspended sentence or probation. There are two different types of probation here in Texas. One is the suspended sentence. The judge or the jury finds that a person is guilty. They assess a sentence on them. And then they suspend that sentence and say, we'll put you on probation. If you do what you're supposed to do, don't commit new offenses, pay your fees and fines, community service restitution, you do all of these things, then your probation case is eventually dismissed and you have a conviction, but you never actually had to go and serve time in jail or in prison. There is in Texas another type of probation called deferred adjudication probation. And with deferred adjudication probation, the judge finds, and it can't be the jury, but the judge finds there's enough evidence to say that you're guilty or person is guilty, but does not do so. Instead, the judge puts off or defers a finding of guilt and just sends this individual directly to probation. And if the individual completes their deferred adjudication probation, then the case against them is dismissed and they do not have a conviction. Okay, is that all clear as mud? So if anyone has a question about whether or not they have ever been convicted of a felony or a misdemeanor theft in such a way that keeps them from being able to serve on the grand jury, I'd ask you to come forward at this time. Let the record reflect no one's coming forward. You also must not be under indictment or other legal accusation for a misdemeanor theft or for any felony. That means that if you've been arrested and posted bond, even if it's a PR bond for a misdemeanor theft or any felony, if you're awaiting to go to trial, if you're on probation, if you're on deferred adjudication probation, then you may not serve on the grand jury. Is there anyone in that situation? Let the record reflect that no one has indicated if they are. Now, you must not be related within the third degree of consanguinity, which means blood, or the second degree of affinity, as determined by Chapter 573 of the Government Code. So what that basically means is I'm going to ask you to, that is related to anyone else in the grand jury. I'm going to ask you to look around, and it may not be as easy as it used to be to determine who you're related to, but it's only if you're related to closely by blood or marriage. And if you see anyone that you're related to closely by blood or marriage, I'm going to ask both of you to come forward, and I will determine whether you are disqualified as a matter of law because of that relationship. All right, so is there anyone here who sees somebody they're closely related to by blood or marriage? I see a hand in the background. Yes, sir. Okay, your name? Okay, and who might you be related to? And how are you related? Okay. And first cousins, second cousins? Okay, give me just a minute. Okay, that is the closest you can be without being disqualified. The aunt or uncle that you're related through, you couldn't serve on the grand jury with them, but you can serve on the grand jury with the first cousin. Anyone else? Yes, ma'am. And how are you related to Mr. Brish? Okay, exactly though how? Or, okay, if it's just cousins, any degree of cousin, that's far enough apart. Okay, but thank you for bringing that up. Okay. You must not have served as a grand juror in the last year. So is anybody here who had grand jury duty last year? No. Okay. You must not be a complainant in any matter to be heard by the grand jury during the term of court, which is to say for the next 6 months. So has anyone been recently burglarized, the victim of a felony offense or embezzlement or something, where you expect that it's likely that the prosecutors or the police department, sheriff's department will be presenting a case to the grand jury for the grand jury to consider, and you are the victim of that case? Okay, all right, then I'll let the record reflect that no one has answered in the affirmative. Okay, now, is there anyone who's had a chance to think about things a little bit and wishes they'd raise their hand and come forward? No. All right, I'm going to go over the excuses from grand jury service at this time. I'm going to ask you to listen to these carefully and then listen to what I have to say next. The last excuse is just a general excuse, okay? I have discretion to listen to just a general excuse. But the first thing that I have are exemptions. And an exemption from grand jury service means that if you are in a certain situation, for instance, if you're older than 70 years of age, all you have to do is come up here and show me, hey, I'm older 70 years of age, and that's, you're gone, you're excused. I don't know how much leeway, if any at all, I have in granting a regular excuse. I've got airplane tickets, you know, in April or something like that. I don't know how much leeway I have in that sort of excuse until I know how many people are going to come up here and claim exemptions. So whenever I ask for people who want to claim their exemptions, if you have a general excuse, please don't come up. Wait until I ask for general excuses. So you may claim an exemption from grand jury service if you're older than 70 years of age. If you are responsible for the care of a child younger than 18 years of age. If you are a student of a private or secondary school, that is a high school. If you are enrolled in an actual attendance at an institution of higher education, okay? So is there anyone who believes they fall into any of those categories and wants to come forward and claim their exemption? All right. Now, I will listen to general excuses. And the mere fact that it might be some hardship to serve on the grand jury is not enough. And some folks, it could be a severe hardship to serve on the grand jury. And before I ask you to come forward with those, I want to talk to you a little bit about your service. As I said, you'll typically serve at most one Friday morning a month. It may not be every single month, but typically that would be the most you would serve. The other thing I need to tell you is if you're ever unable to serve and you have to be replaced, you cannot be replaced for just one meeting of the grand jury. You're either a grand juror or you're an alternate or you're not on the grand jury at all. Meaning that if you have to be gone for 2 months to go to a class or a seminar somewhere, I need to know about that because you can't just dip in and out of grand jury service. You've got to either be here or be excused permanently from the grand jury. So is there anyone who wants to come up with a general excuse? All right. And let me just ask, what is your, come forward, sir, just to mention, what is your name? All right. Yes, Mr. Kiner.
I know I'm in the National Guard and everything, and I know in June I've got
18.
18, yes. So I'll be out 2 Fridays for sure then, and then on my drill schedule, actually this Friday, I've got drills, so
Okay. All right, I will take that. I appreciate your service. I will take that under consideration. Let me see how many we have.
All right.
I think it'll be plenty. But...
Oh, thank you.
Okay. And do you know when you're going to AT, the end of the month, last 2 Fridays, or you don't know yet?
I can tell you.
Let me see when the grand jury is scheduled to meet.
As of right now, it's the 12th through the 26th of June. That's
Okay.
That's subject to change, as usual.
All right, sure. And they don't actually have the grand jury meeting in June on this calendar. So right now I'm going to ask you to remain, and we just have to tell the DA's office they need to meet. They should do it on the 4th. All right, thank you, sir.
Yes, sir. Thank you.
Anyone else? All right. So we haven't lost anyone. So the first 12 in order ought to be the first 12. All right, so let me ask the clerk's office to call the first 12 names, and then let me ask them to stand.
Dusty Culpepper, Jason Taylor, J.C. Garcia, Javi Joe Dragon, Marcelino Castaneda, Jamie McNeil, Paul Martinez, Irma Garza, Nisa Gervais, Irma Leal, Sydney Martin, Sabrina Mendoza,
All right. Okay, and then the next 4, the alternates, ask them to stand also.
So Michael Michigamba, Harold Rios, Deborah Liska, Dennis Fritz.
Okay, and let me ask Mr. Muchigimba, were you able to hear everything going on in the court? Okay. All right, Mr. Muchigimba, and you had come up earlier and asked to be excused on account of your hearing. And I said, typically when we're not having COVID, the grand jury meets in a small room, it wouldn't be an issue. But it is an issue. The acoustics in here are like a basketball stadium or arena. So I will excuse you. Thank you for being here. And let me ask for Dennis Brish to stand up. All right. And then next would be Craig Bordowski. Okay. All right. Then I'll find that the 12 people on the grand jury represent a fair cross-section of the members of Atascosa County. I'm sorry, Karnes County. I'm the judge for 5 counties, and I'm thinking about a different one right now. I apologize for that, y'all good folks. Okay, so let me ask the 12 members of the grand jury and the 4 alternates to please take this oath. You solemnly swear or affirm that you will diligently inquire into and true presentment make of all such matters as may be given you in charge. The state's counsel, your fellows, and your own you shall keep secret, unless required to disclose the same in the course of a judicial proceeding in which the truth or falsity of evidence given in the grand jury room shall be under investigation. You shall present no person from envy, hatred, or malice, neither shall you leave any person unpresented for love, fear, favor, affection, or hope of reward. But you shall present things truly as they come to your knowledge, according to the best of your understanding, so help you God. All right, is there anyone who didn't take the oath out of those 16? All right, you may be seated. And ladies and gentlemen, for the rest of you, we've been able to impanel the grand jury without using you. I appreciate very much that you were here and that you were willing to serve. Another judge actually impaneled a grand jury in Atascosa County earlier this month, and they didn't have enough people show up to get 4 alternates. They wound up with just 2 or 3 alternates, not even a full number of alternates. So your population is less than half of that, and you've got quite a few left over. So I appreciate your service. Who should they get with who to be in?
What I'm gonna do is I'm gonna mark down the name and we will send it by email.
Okay, so I will give the people who are excused, you're welcome to stay and watch. You're welcome to take off. If you want to take off, I will give you an opportunity to do that right now. All right, ladies and gentlemen, I'm going to talk to you a little bit about your duties. Again, you'll be meeting here at the courthouse every month or every other month. Whenever you finish your job every day, if you have indictments that you have returned and there happens to be a judge here, which with COVID there probably will not be, the court indictment should be returned to the district judge in open court. The district judge is not present in the Karnes County courthouse, and I'll tell you that in this judicial district, there are 2 judges spread over 5 counties, so typically there's not going to be a judge here. Then you must return the indictments to the district clerk. You must have at least 9 members present to have a quorum, and you cannot do any work as a grand jury unless you're together and acting as a group. You must have at least 9 affirmative votes to return what's called a indictment or a true bill, okay? If you have only 9 people there, obviously it must be unanimous. If you have the full 12 members of the grand jury present, then you still need only 9 votes to return an indictment. Whenever you consider a case that the state's attorneys present to you, you can return a true bill of indictment, meaning that you find that there is enough evidence that shows that there probably has been an offense committed and that that person the state accuses probably committed it. You can return a no bill or no indictment, meaning that you don't find that. You can pass the case for additional information. You can tell the state that you prefer not to vote on it, that you want them to bring you back some more information. And you can also decide that you think that there probably was an offense and that the state's defendant probably committed it, but that you also believe that it's a misdemeanor offense, and you can refer that case down to the county attorney's office for prosecution as a misdemeanor. Again, your function is to serve as a screening service between the government and the citizens. And is doing that, you investigate indictable offenses by summoning witnesses and seeking advice from the district attorney's office. But remember that you're an independent body and you do not act as a rubber stamp for the district attorney's office. You can seek their advice, but you must act independently. Now, this is probably the most important part. All of your deliberations are secret. You may not reveal the contents of any of your deliberations to anyone, not a spouse, not a friend, no one. Now, there's a lot of very archaic language in that oath that you just took. That oath has been around for 100 and something years here in Texas. But what you just swore in your oath is that you will not reveal anything about your work as a grand juror unless you are summoned to testify in a court case about whether or not someone lied to the grand jury. Now, keep in mind that you're going to be considering cases that have all sorts of allegations of wrongdoing, and there's a couple of things to think about. One, it may be that someone has been accused of committing an offense, a particularly heinous offense even, and there's no merit to the accusation, or apparently no merit to the accusation, that all of y'all look at it, you consider it, and you return a no bill of indictment, a no bill, meaning you don't indict it. That's the end of the matter usually. However, if you do that and then you go out and say, hey, you know, old Joe Blow, he was accused of molesting a child, or the person at the bank was accused of swindling from an elderly lady, you could ruin somebody's reputation. So you hold their reputations in your hand. Don't go talking about what happened in the grand jury room. On the other hand, it can also be that if you have ongoing investigations or investigations that aren't 100% completed, or there's a series of criminal acts, if you go running around in the outside of the grand jury room and saying, hey, we just returned an indictment against so-and-so, or the sheriff's department and the Rangers are investigating this individual for drug trafficking, then you could jeopardize cases. So don't doing that. Whatever happens in the grand jury room stays in the grand jury room. So I said, your job is not to determine whether someone is guilty. There will not be a defense attorney there. You won't hear witnesses on both sides. There'll be a trial later in front of either a judge or a jury where guilt is determined. You're just trying to determine whether there's probable cause to believe that an offense was committed and the person the state accuses probably committed it. The grand jury should not ever, in any circumstances, get involved in politics. Your duty is to investigate crimes or offenses. The grand jury is not supposed to be making new laws. They're not supposed to be going out, handing out retribution. They're supposed to simply be deciding whether there's enough evidence for someone to be required to stand trial in a felony offense. There are no friends coming in front of you as grand jurors. There are no enemies. They're just potential defendants. Now, again, going back to that old oath that you took, the language in that, it says, you shall present no person from envy, hatred, or malice. And by present, that means return a bill, an indictment against them. Neither shall you leave any person unpresented or unindicted for fear, love, favor, affection, or hope of reward. But you shall present things as they truly come to your knowledge to the best of your understanding. All right. So no friends, no enemies back there. It's just whatever you believe that the evidence shows. Another thing I'll add to on the secrecy part of the grand jury proceedings is that, as I said, there's typically the full grand jury. If everybody's present, there are 12 folks deliberating. It takes 9 votes to return an indictment. If there is a no bill or no indictment, all anybody knows is that there were not 9 votes to indict. If there's an indictment, all anyone knows is that there were 9 votes to indict. Now, if you have a criminal trial for guilt or innocence, the jury has to be guilty. If there's an acquittal or if there's a conviction, everybody knows that everybody on the jury voted that way. As long as the secrecy of the grand jury is maintained, if there's either an indictment or there's not an indictment, nobody knows how the vote went. It could be if there's a no bill that there were 12 votes against indicting that person, but we don't know that. It could be if there's an indictment, there could have been 9, 10, 11, or 12 votes. So neither we nor anyone in the public will know how you voted. Keep that in mind. Now, I typically need to appoint and will appoint the first person on the list as the presiding grand juror. The presiding grand juror has several duties. One is to help keep in touch with the district clerk's office and the other members of the grand jury, okay? And especially with all the COVID stuff going on, if it turns out that you've got, somebody, Mr. Kaner gets called up for National Guard duty and you have 3 other people who are out with COVID, well, you only have 8. And there's no sense to 8 of you trooping down to the courthouse to say, oh, we've only got 8. We can't meet. We have to either reschedule, or if somebody's going to be permanently out, we have to excuse them and put in one of the alternates. The other things the presiding juror does is that they'll preside over your deliberations, and the grand jury is in charge. If you've heard a few cases in the state and you want to stop and think about those and vote on them, you make that call, and the presiding juror is the one who'll tell the state, when you're ready to take a break, when you're ready to take a vote, things like that. The presiding juror is also the one, if there is an indictment returned, who signs the actual indictment. So I'll ask Mr. Culpepper, would you be willing to serve as the presiding juror? Yes. All right. Okay. All right. Now, the 4 of you who were 3 and 1 who are alternates grand jurors. As I said, this is not like it's more like being somebody on the bench in a baseball game, if I can use that analogy. If you get sent in, you get left in. It's not like football or basketball where you can just get sent in and taken back out. So the only time you would serve would be if somebody who's on the grand jury is permanently excused because, for instance, they moved out of Karnes County. So we need to make sure that you meet with the clerk's office, that you give them good contact information for you. And if we need to contact you in the future, they will get in touch with you about saying that you've been moved up to the grand jury. All right. So I will give y'all a moment to be excused. And then I need to get the bailiffs in here.
We're waiting for the court to take them out, and then excuse them.
Yes.
After we record their information.
Yes. Okay, are we going to have any other bailiffs for the grand jury? Okay. If we could get them in here for a moment so I can swear them in. Oh, I'm sorry. Just the two of you. I didn't see. I thought there was somebody outside. I thought Javier or somebody was outside.
No, he's out. He's out.
Oh, really? Oh, I had not heard that.
Well, his niece.
Okay. Oh, okay. My sister-in-law did, but we hadn't been around her, and that was November. Okay, may I ask, do you solemnly swear, each of you, that you will faithfully and impartially perform all of the duties of bailiff of the grand jury, and that you will keep secret the proceedings of the grand jury, so help you God?
Yes, sir.
Okay, and your name for the record?
Felix Casanova.
And your name, sir?
Tim Bowen.
All right. Okay, and is the state's attorney here?
Yes.
Okay. All right then, so at this time, I'm going to, what am I going to do? I can't stay here because they're going to meet. Okay. All right. At this time, I am going to leave you here. Typically, I excuse you to go off with the DA's office to the grand jury room or jury room, but at this time, I'm going to pause myself on the Zoom meeting, and I'm going to go downstairs and see if the internet is fast enough downstairs for me to be able to conduct the rest of the court from downstairs, because again, the jury meetings are secret. So let me get here. I suppose y'all heard that. Let me see. All right, it says that Ms. Riley is still the host. So I am going to pause, shut down my computer, and I will be back briefly. Sure. And you're free. Oh, yeah, I mean, you're gonna set up here. Where can Lachey set up that she could?
Judge,
The one right near.
Judge Wilson, this is Lori.
No, I need a packet of everything.
Okay, all right. Okay, so let me just put this away, and I'll try to keep my computer up.
Judge Wilson, can you hear me? This is Lori.
I was not muted. Yes, go ahead.
I'm so sorry. Is Lachey happen to be there? Because I inadvertently did not send her the Zoom invite for today's hearing, and I apologize for that.
She is here, but she is moving where she is. So if you'll send her the link, she'll sign on shortly.
Okay, I sent it to her, and did I missed the very last? I was trying to call her. Did you say the peelers are still coming back at noon? Is that correct?
Yes.
Okay, great. Okay, thank you so much.
Okay, I have noon. On Mr. Lanfear's motion, I should have done that before I took off. Let me ask, is that completely agreed or?
I thought it was, Your Honor, but I think Hewitt is unable to agree at this point.
All
Your
right,
Honor, Mark Guthrie for Kiewit, that's correct. I anticipate being able to agree, but I just don't have client approval yet.
all right. I don't see Mr. Lanfear.
He has drafted a proposed order that I think everyone but Kiewit has agreed to, including the deadline for completing what will be our second mediation, Your Honor.
Okay, and
That's
when is
correct.
that? What would that deadline be?
April
August 20
23.
sorry, April.
Okay. All right, Mr. Guthrie, I want the mediation to take place, but I don't want to get your clients back up because I jumped up and ordered it while they were considering. So do you think it would help to delay this for a day or two?
I think that would be good, Your Honor.
All right. Okay, then I will reset this. Are we here all 3 days this week then?
We're here on Thursday, Your Honor.
All right, I'll reset this for Thursday.
Thank you, Your Honor.
And you won't see me looking up at my second monitor because I'm still in Carnes this morning. Sometimes it's better to be lucky than good. The Carnes County District Clerk had told everyone who checked in online, which they were all supposed to do, to be here at 10 a.m. So I got here before 10 a.m. and there were only people who were here were those who had failed to follow instructions. So I was able to be here, even though I didn't show up in the right place at 9 a.m. All right, San Miguel, Peeler motion to exclude Kenneth Donahoe. Is that Donahoe or he calls it Donahue?
I believe it's Donahue, Your Honor.
Okay. All right. And Mr. Schick, are you going to argue that or on the response?
No, Your Honor, Maggie Pelosi will be responding to that motion.
All right. And I just want a little bit before we get in the weeds on this. What relevance would there be to some question the jury has to decide what the impact on the electrical grid would be? Anyone?
Well, Your Honor, I can speak to why we designated an expert regarding the electrical grid, and that is because San Miguel argued in their temporary restraining order.
Your Honor, I didn't hear that well.
All right, go ahead, Ms. Whittle.
Your Honor, the San Miguel argued in its motion for temporary restraining order, and that also serves as its basis for its request for a permanent injunction, that exclusion from the Peeler Ranch would cause rolling blackouts on the Texas grid. And so we designated a retained expert to respond to that argument. And I believe Mr. Donahue is designated by San Miguel to respond to our expert.
That's correct. Mr. Donahue is designated as a rebuttal expert to respond to the Peeler's expert, Mr. Fagan.
And what would the jury question be there?
So, Your Honor, I believe the issue is whether San Miguel could be shut down now, as the Peeler's expert claims, with no impacts to reliability on the grid.
It would be a question of whether an injunction is a permanent injunction is appropriate, and whether the argument that San Miguel made regarding if the Peelers win, their argument is that we will cause rolling blackouts in the state of Texas due to grid reliability issues. And so this was our response to that argument. Since it's based on the injunction, I'm not sure there would be a jury question regarding it. It would be a judicial question.
Okay, all right, because I didn't see that there would be a jury question. Okay. Go ahead, Ms. Whittle.
Actually, Your
Or
Honor,
Mr. Guerrero, yes, she's muted, so you're up.
Okay, thank you, Your Honor. May it please the
Should
court.
have walk-up music like the baseball players for the attorneys, just a little few seconds. All right, go ahead, sir.
I'll work on finding some of that, Your Honor. May it please the court.
Yes.
The appealers have filed a motion seeking to strike the expert testimony of Kenneth Donahue, a rebuttal expert designated by San Miguel and Steck to respond to the opinions of the appealers expert Bob Fagan. Both Mr. Fagan and Mr. Donahue offer opinions related to San Miguel's request for a temporary restraining order, which is what initiated this lawsuit. And this goes to the question Your Honor just asked. And I'm going to share my screen here.
Go ahead.
Thank you. And are you able to see my screen?
Yes.
Great, thank you. In seeking the TRO, San Miguel alleged that the appealers' claims would result in the closure of the San Miguel power plant, which will in turn most likely cause shortages on the state power grid, which could lead to rolling blackouts across the state. In the petition, which is up on the screen right now, they focus their concern on harm that was to occur that summer, but the opinion offered by their expert has grown into perpetual concern, specifically that San Miguel must stay online for an indeterminate amount of time. No time period was given when Mr. Donahue was questioned at deposition as to when San Miguel could be closed, and that the power plant cannot be closed without dire consequences, such as risking the reliability and damaging the entire Texas grid. And you can see there they cite in their petition that there is going to be damage to the Texas power supply. In order to respond to these allegations, from the sweeping harm that San Miguel claimed this single plant could cause to the entire state, the appealers retained Bob Fagan, who prepared a report analyzing the impact of the closure of the San Miguel plant. Mr. Fagan is a mechanical engineer and energy economics analyst with over 30 years of experience in the energy industry. He's vice president of Synapse Energy Economics, and his work is focused primarily on electric power industry issues, especially economic and technical analysis of transmission, wholesale electricity markets, renewable resource alternatives, and assessment and implementation of demand-side alternatives. Mr. Fagan's qualifications are set forth in his report, which is attached to our motion as exhibit number 1. Notably, his experience includes work on the characteristics of the physical transmission network, which is important here, the operation of the related generation dispatch system, the technical and economic attributes of generation resources. And he's also experienced in the fundamentals of electric distribution systems and substation layout and operation. In his report, Mr. Fagan, again, this is the appealers expert, concluded the San Miguel plant could be retired as early as summer 2020, because even with the retirement, the reserve margin would remain well above acceptable range, and the reserve margin would continue in an acceptable range into the future. He also concluded that there was no indication that reliability of the grid would be adversely affected with San Miguel's closure. He also found no transmission-related concerns without the San Miguel plant, based on ERCOT annual reports on identified and projected constraints and needs, and ERCOT's long-term system assessment. Unlike every other expert offered by the appealers, the coal companies did not challenge the reliability of Mr. Fagan's opinions, nor did they challenge his qualification to offer those opinions. Briefly, Your Honor, I'd like to talk about ERCOT, which I mentioned earlier, and its central role with respect to grid reliability, because it has to do with Mr. Donahue's ultimate opinion. What is ERCOT? ERCOT is the Electric Reliability Council of Texas. This on the screen is a publicly available fact sheet from ERCOT's website about the organization. ERCOT manages the flow of electric power to more than 26 million Texas customers, which represents about 90% of the state's electric load, including, as you can see on this map, all of South and Central Texas. ERCOT oversees more than 680 generating units. They oversee more than 82,000 megawatts of power. Notably, San Miguel constitutes about 400 megawatts of power, or less than 0.5% of what ERCOT oversees. They also oversee more than 46,500 miles of high voltage transmission. As the state's main power grid operator, one of ERCOT's primary responsibilities is to maintain system reliability of the electrical grid of generation and transmission resources. That's their number one responsibility listed on their fact sheet. This is consistent with how Mr. Fagan, the peelers expert, describes ERCOT. ERCOT operates an almost statewide energy market to balance the physical flows of electricity across the shared transmission system. In other words, ERCOT specifically is tasked with and adequately handles a proactive process to rebalance electrical needs if and when a particular power source is unavailable, both minute by minute and also long term. That means if a plant unexpectedly goes offline, ERCOT reacts by rebalancing as needed. If a plant is down for maintenance, either planned or unplanned, ERCOT likewise reacts. And if a plant closes, ERCOT reacts. In fact, in Mr. Fagan's report, ERCOT is routinely involved. He notes that ERCOT is routinely involved in plant closures. He includes a list of plants, and these plants that are up on the screen are coal plants within ERCOT that have been taken offline in 2018 and 2019 with ERCOT's involvement, a total of 5,583 megawatts. As noted earlier, San Miguel produces about 400 megawatts, which compared to the plants that closed in 2018 and 2019 is on the smaller side of the plants. Just to give you a very quick feel for the for ERCOT and their work, here is where much of the monitoring and reactions occur. The ERCOT Grid Control Center, which is a large facility in Taylor, Texas, that's constantly monitoring the grid. This is the facility itself in Taylor, which is just north of Austin. Mr. Donahue's expert, Mr. Donahue, San Miguel's expert rather, describes ERCOT consistent with Mr. Fagan's. They agree on what ERCOT's supposed to do. At his deposition, Mr. Donahue was asked, "Tell me generally, what does ERCOT do?" And he replied, "ERCOT is the independent system operator for the ERCOT grid. They are also the planning authority. They also run the operations and the ERCOT market." And then he was asked, "What do you mean by operations?" He said, "The actual operating of the grid." What does that include? He said, 2 programs, 24/7 operations around the clock, reliability under all situations. Notably, Mr. Donahue, who again is San Miguel and STEX expert, used to work for ERCOT from between 1997 and 2008, leaving about 12 years ago. All of the deposition citations that I have in today's presentation are in the Peeler's motion as exhibit number 4. So this brings us to Mr. Donahue's central opinion, which is that San Miguel must remain in service to maintain grid reliability. And you can see the language there. This executive summary that I have up on the screen is the entire executive summary. His report is concise and distinct, and you can see that it says there that the San Miguel plant must be in service to meet reliability requirements, and that its closure would reduce transfer deliverability from other plants to consumers in and out of South Texas, excuse me. Notably, he uses the word must, which is why it's underlined there, and includes no limitation in time, meaning that there's no scenario where San Miguel could close without potentially causing rolling blackouts across Texas. And so what did Mr. Donahue do to come to this conclusion? Mr. Donahue was asked by San Miguel's attorneys to perform what he called a steady state analysis of what would occur if San Miguel were taken offline. During his deposition, he described the steady state analysis as a one instant in time look or a snapshot of what might occur at a particular moment if the plant was taken offline. Mr. Donahue's analysis focuses on the impact of the closure of San Miguel on electricity transmission and resulting impacts to the grid. In reaching his conclusion, Mr. Donahue modeled various scenarios, which included the grid reliability under normal circumstances if the San Miguel plant were out of service. So the first thing he looked at is under normal conditions, what would happen if San Miguel were taken out of service? He also looked at grid reliability under contingency or abnormal circumstances if the San Miguel plant were out of service in 2 different years, 2020 and 2023. I'll note that Mr. Donahue provided his report in February of 2020. The scenarios that he modeled were based on ERCOT's established models. In analyzing reliability, Mr. Donahue looked at a couple of components. Thermal limits, which establish the maximum amount of electrical current that a transmission line or electrical facility can conduct over a specified time period before it sustains damage by overheating or before it violates public safety requirements. And in addition to thermal limits, he looked at voltage limits, defined as system voltages and changes in voltages that must be maintained within the range of acceptable minimum and maximum limits. So considering both of these factors, Mr. Donahue concludes that under normal conditions, the San Miguel power plant had limited impact on the losses within the study area. In other words, Mr. Donahue, his results were that if the plant were taken off the grid today, unless there were some extraordinary event at the same time, Texas Electric customers would see no impact under normal conditions. So let's set aside normal conditions. Let's look at the contingency conditions. Mr. Donahue next looked at 4 separate contingency scenarios. These are conditions that would be outside expected normal conditions. These 2 are also ERCOT models that he used and are based in conditions anticipated in 2020 and 2023. He ran each scenario twice, one with San Miguel online and one with San Miguel offline to determine if grid reliability would be impacted by taking San Miguel offline. For the 2 2020 scenarios, Mr. Donahue found that the closure of the San Miguel plant would not impact the grid reliability in any significant way. And so the 2020 scenarios he ran showed no problems with taking San Miguel offline. And remember, for each of the scenarios, he ran 2 different runs, one with San Miguel online and offline. So that takes care of 1A, 1B, 2A, and 2C, all of the 2020 scenarios. For the first 2023 scenario involving summer peak conditions, the summer loadings were within acceptable thresholds as well. No significant impact to grid reliability. And Mr. Fagan discusses this. So on 3A and 3B, under that model, looking at projected 2023 summer peak conditions, taking San Miguel offline had no impact on the grid. Only on one contingency scenario did Mr. Donahue determine that there might be an impact to grid reliability, and this was including the abnormal condition of high wind with a low load occurring in 2023. Importantly, as I discussed earlier, these scenarios are only a snapshot in time. And once Mr. Donahue identified that this single 2023 contingency scenario that projected a potential harm under the assumed future static grid conditions in 2023, he stopped work. His analysis ended. He completely failed to consider if some mitigating action might prevent the projected harm in 2023, even though such mitigation is the reason ERCOT exists, and it's a task that it accomplishes on a day-to-day basis. This is where the analytical gap exists, him failing to look at what ERCOT would have done. If ERCOT performed this same modeling that reflected a potential grid reliability issue occurring 2 years from now in 2023, based on this high wind, low load situation during which San Miguel was closed, ERCOT's duty would be to act to ensure proper dispatch of resources in the region to mitigate these identified violations. That is, they come up with a mitigation plan, which is part of the reason for ERCOT's existence. Yet, Mr. Donahue's conclusion that the plant must remain online to avoid violations in this one scenario pretends that ERCOT would do nothing. Indeed, when the plant has historically been out of service, which it has in the past, for planned maintenance or because of a forced outage, ERCOT has supported the reliability of the grid using other resources which provide sufficient voltage control, frequency response, and system strength to support power transfers, as stated in the rebuttal report of Mr. Fagan. Put another way, when the plant has been off in the past, it hasn't caused rolling blackouts across all of Texas, as San Miguel now argues. These resources and others remain available to ERCOT now and in the future. And by these resources, I mean the resources that were employed when San Miguel was previously taken offline. During his deposition, Mr. Donahue stated, again, ERCOT is controlling the grid under operations, running contingencies every day, and they continue to operate the system under those contingency limits. He was asked, and ERCOT is continually responding to different changes within the system, such as violations, correct? Such as the violations he found in that one scenario. And he answered, yes. He was asked, that is one of their main reasons for existence, to identify and to respond to violations or to coordinate a response to violations. Fair? And he said, yes, sir. He was further asked, so when you run these studies and the studies show a violation, what should be done in response to the violation? Are there steps that can be taken to alleviate or mitigate the violation? And he says, are you referring to actual operations or in planning? And I say, yes, sir. And he said, ERCOT continually monitors the grid, running contingencies around the clock. If they find a violation, they will try to come up with a solution. And there's many different things that they can do. They could change dispatch and generation. They could change topology of the grid. Ultimately, they might have to take some type of action on taking a piece of equipment out of operation, or as a last report, I believe that's supposed to be resort, if interrupting load is an option, they would consider that. They try to come up with a mitigation plan. So despite this testimony of what ERCOT could and would do, Mr. Donahue's opinion relies on a fatally flawed mythology. He presumed a static grid where ERCOT would do nothing, even though he confirmed himself that this assumption is unrealistic because ERCOT exists in order to mitigate potential grid issues by modifying the grid to address potential harm before it occurs. When asked about this specifically during his deposition, Mr. Donahue confirmed that he reached his conclusion in this case that taking the plant offline would harm grid reliability throughout the state without considering the steps that ERCOT would take under those circumstances, which again is the analytical gap here. Okay, I'm not asking, he was asked, and I'm not asking about whether or not it helps the situation or it improves the situation. The language that you used in your opinion is that San Miguel must remain in operation. Must is the word you used, Mr. Donahue, and must to me suggests that that is the only option. And so what I'm asking you to articulate is how you were able to come to that conclusion when you've not looked at other possible situations where San Miguel is not operating and other system changes could be made that would alleviate the violations. His answer was, there are many things that could be done to look at those. My analysis is based upon these snapshots in time over 2020 to 2023. So he was asked, and so you've acknowledged that there's many options to address this, but you and the work that you performed did not look at any options at all, correct? And his answer was, we did not look at those. But based upon my 37 years of experience, yes, there are options that could be taken, but I did not do that in this analysis. Mr. Donahue's conclusions are unreliable. He ignores his own results that taking the plant offline would have no effect under normal conditions, and he relies upon the patently wrong assumption that ERCOT would do nothing to adjust the grid if removing the plant from the grid actually threatened future harm in 2023. In their response, San Miguel and STEG argue that factoring in ERCOT actions would require running new speculative models. But the analytical gap here isn't about running new models. It's about Mr. Donahue's complete failure to perform any analysis whatsoever as to whether or not ERCOT had mitigation plan options that could be applicable, and explaining why he ruled those out. He acknowledges that mitigation plans are possible and that this is why ERCOT exists, but makes no effort to explain why a mitigation plan would not be viable in the single contingency scenario where he found a violation. It would be a different scenario had Mr. Donahue performed any analysis, such as identifying potential mitigation actions that ERCOT might have taken and finding that such action would not have fixed the violation. But instead, Mr. Donahue did nothing. The gap in his analysis is further underlined by the fact that he has no knowledge and, truly judging by the testimony, no curiosity about the impacts, if any, to grid reliability when San Miguel has had prior outages. He did not even look to the past to see if prior outages at San Miguel had any impacts on grid reliability or ever caused rolling blackouts across Texas. He was asked, how many times in the past year, Mr. Donahue, has the San Miguel plant been offline for plant maintenance? And he responded, I don't have any information relating to that. He was asked, how many times in the last year has the San Miguel plant been offline due to a forced outage? I don't have any information relating to that, he responded. And you don't have any information relating to San Miguel being offline for any time period? And he responded, no, I really don't have a lot of information. I heard there was one time last spring, but that's all I know about. Then he was asked, do you know how many times per year generally that they're down for plant maintenance? And he says, no, I do not. I would suspect 1 or 2 times. Are you aware of any periods during which San Miguel was offline, during which ERCOT had any problems with voltage control, frequency response, or system strength? No, not aware of that information. Later in the deposition, he's asked, would you agree that there have been periods where San Miguel, the power plant, has been out of service where the group, I believe that should be grid, continued to operate reliably? And he answers, again, that would be, I haven't had any information, but again, that would really, ERCOT would have to do the analysis when it goes offline to see if there are any issues. I haven't any information to that. And coming to your opinion, he's asked, you didn't think that looking at instances where San Miguel was previously offline, you didn't think that was pertinent to your opinion? And he responds, I'm sure there are times that San Miguel is offline where they have come up with some possible reliability impacts. ERCOT would have to try to operate around that or come up with a mitigation plan, as I believe that's how that's supposed to read. And so that's what we're saying. ERCOT would have to operate around that and come up with a mitigation plan. He did not consider ERCOT's options for mitigation plans, did not consider past outages and how those impacted grid reliability, or if mitigation measures were put in place in those past outages, yet concludes that San Miguel must continue to operate under any circumstances to some indeterminate date in the future. Put another way, Mr. Donahue's opinion is that there is no scenario at all under which San Miguel, this single 400 megawatt plant, one of among more than 680 generating units overseen by ERCOT, and only less than 0.5% of the generation that ERCOT oversees, Mr. Donahue concludes that there is no scenario at all under which San Miguel can close without impacting the Texas grid and causing these rolling blackouts. He offers this opinion despite San Miguel's absence having no impact on grid reliability under normal condition scenario modeling, despite San Miguel's absence having no impact on grid reliability in 3 of the 4 contingency scenarios that he analyzed, and despite the fact that he did zero analysis as to what mitigating action ERCOT could take to address any violations in the sole contingency scenario that he identified as problematic. And he also came to this conclusion despite a clear lack of knowledge as to whether or not prior San Miguel outages had actually impacted grid reliability. This is the precise type of analytical gap and incomplete analysis that supports exclusion of an expert's opinion. I have a couple of other points, Your Honor. During his deposition, Mr. Donahue, in an attempt to salvage his opinion, attempted to offer new opinions based on scenario models that he did not run. Specifically, the 2020 models that he did run, as I showed you earlier, did not show any impact to grid reliability if San Miguel closed. Yet, towards the end of his deposition, he attempted to argue that the 2023 high wind, low load model that did show a potential problem, he said, well, basically that could occur in 2020 as well. This opinion was not in his report, and he had no basis for this opinion. He didn't run any model for 2020 reflecting high wind and low load. In the past several weeks, as the court is aware, San Miguel has reportedly disregarded the actual foundational work and analysis performed by many of the peeler's experts, characterizing their opinions as ipsy-dixit, or mischaracterizing their opinions as ipsy-dixit, whenever San Miguel disagreed with their analysis. In contrast here, Mr. Donahue's attempt to salvage his testimony by injecting an opinion for which he has no foundation and performed no work is a clear example of ipsy-dixit. We believe this is a further basis to exclude Mr. Donahue as an expert. One additional basis for exclusion. During Mr. Donahue's deposition, when he was asked about his report, Mr. Donahue testified that he destroyed a paper copy of a draft of his report that he reviewed with counsel for San Miguel. He sat with San Miguel's lawyer, claimed he read the report aloud, and that changes were discussed, and he acknowledged that he subsequently changed his report after this meeting. This is in his deposition, and it's cited in our motion. He was asked, what did you do with the copy of the report that you brought to Mr. Holcomb's office? Mr. Holcomb is counsel for San Miguel. He replies, I don't understand. Mr. Donahue was then asked, you said that you had a paper copy of the report that you brought to Mr. Holcomb's office. And he replies, right. Where is that report now? Mr. Donahue says, destroyed. We don't keep drafts. He was asked, when did you destroy it? He said, right after I made more changes to it. We raised this issue in our motion, and San Miguel and Steck responded. There's no evidence that the paper copy is substantially different from Donahue's final report, as Donahue testified that he only revised the report to clarify confusing technical language and make the report more understandable to laymen. Well, I'll note that there's no evidence of what's in the report because Mr. Donahue destroyed it. He didn't lose it. He didn't misplace it. It was not inadvertent. He destroyed it. San Miguel and Steck, in their response, cite the Harris County Appraisal District case in their response. But this case is distinguishable because it involved an unintentionally lost work file, not an intentionally destroyed draft report used at a meeting with counsel that resulted in changes to the expert report. We are entitled to know what language was changed, and San Miguel's assurances in their response are not a substitute for appropriately complying with discovery obligations. Rule 194.2 of the Civil Procedure Rules requires that an expert disclose all documents or reports that have been prepared by the expert in anticipation of their testimony. It doesn't require that the production of only documents that the expert chose not to destroy. It's within the court's discretion under 193.6 for failure to properly respond to a discovery request or Rule 215 as a discovery sanction to exclude Mr. Donahue's testimony. For these reasons, we ask that the court exclude his opinions and testimony.
All right, Ms. Pelosi? You're still muted.
My apologies. We ask that you deny the motion to exclude the testimony of Ken Donahue. Mr. Donahue is an expert in transmission system reliability with 37 years of experience, including 11 at ERCOT. As Mr. Guerrero explained, Mr. Donahue is being offered here to rebut the testimony of their expert, Mr. Fagan. Mr. Fagan concludes that there will be no impacts to the grid and there are no transmission concerns from taking San Miguel offline, largely by looking at ERCOT long-term planning reports in which San Miguel is still online. In contrast here, Mr. Donahue has applied the recognized analytical techniques of his field and those that are used by ERCOT to assess transmission system capacity and the reliability of the grid. And based upon that, he concludes that with the grid in its current configuration, San Miguel is necessary to provide transmission support. Your Honor, there are three topics that I'd like to address with you today. First, I would like to begin by talking a little bit about how the transmission system works and how transmission capability is assessed, because I think that's important to understanding Mr. Donahue's opinion. Second, I will respond to some of the concerns that the appealers have raised and explain why Mr. Donahue's testimony is reliable. And then finally, I do want to address the issue of this draft report. So to begin with, Your Honor, the safe and reliable delivery of electricity requires both that there be enough generation capacity, so that's the supply of electrons, and the transmission capability to move it from where it's generated to where you need it. As Your Honor is likely well aware, there are lots of generation resources in Texas that are quite far away from the cities and other places where power is needed to be consumed. So those electrons don't do you much good unless, one, there are enough of them at all times, and two, you can move them from where they're generated to where they're needed. Now, the transmission capacity of a system is impacted both by the capacity of the physical equipment and where on the system electric generation is located. Both of the experts here have discussed the fact that power flows along the path of least resistance. That's a matter of simple physics. So what that means is that when you're assessing the transmission capacity of a system, it's not as simple as saying, do I have a line from point A to point B that the electrons could theoretically travel on? You also have to know what else lies between point A and point B. So it becomes a rather complicated modeling analysis to understand if the system can safely transmit power to where it's needed. One of the reasons that we pay such careful attention to transmission capacity is because when the capability of the system is overtaxed, bad things can happen. The first of which is blackouts. If a piece of transmission equipment, fails, power can be lost in an area.
And in more extreme cases, if transmission system equipment becomes extremely overloaded, it can cause fires. To make sure that those things don't happen, the system has to be operated within its system operating limits. Those are engineering limitations to ensure the safety and reliability of power distribution. Now, here in the US, the North American Electric Reliability Corporation, or NERC, is the regulatory authority charged under the Federal Power Act with developing and enforcing the reliability standards. And NERC requires ERCOT to develop the system operating limits that apply to the Texas grid. When the system operating limits can't be met, changes to the grid are required. In addition to the day-to-day balancing that Mr. Guerrero was talking about, in many cases when a system operating limit can't be met, the changes that are required are things like new transmission or infrastructure that takes years to build. And ERCOT itself doesn't have the ability to build that transmission. They have to work with the owners and operators of transmission in the state of Texas and to help, encourage them to do that construction. Because we expect that the lights will stay on all the time, the kinds of modeling analyses that ERCOT is doing look not only at the normal operating conditions, but also at what happens if something goes wrong and the system is overtaxed. You've already heard Mr. Guerrero talk about what contingencies are. Under the reliability standards that have been developed by NERC, the federal regulator, they require that the system operator, here that's ERCOT, ensure that transmission systems can operate without reliability disruptions under a range of contingencies. So you have to look at what happens if a power plant goes offline, if you lose a transmission circuit, if you lose a transformer, or what happens if you lose a couple of those pieces of equipment at once. And the reason for that is because if it's a really hot day in Texas and everybody needs their air conditioning and a single transformer fails, we don't want everyone to lose power. And so contingency analyses become a really important part of maintaining system reliability. Now, I'd like to move on to talk a little bit about Mr. Donahue's opinions and why they're reliable. As Mr. Donahue explained in his report, his analysis applies the models that ERCOT has developed to look at transmission system capability into the South Texas grid, and he looks at how it will work with and without San Miguel in operation. He does this in accordance with NERC's reliability standards and ERCOT's planning guidelines. And he looks at the 4 cases that Mr. Guerrero has already been over. This analysis is looking at the occurrence of the violations of the system operating limits with and without San Miguel under the ERCOT model, and it includes normal operations and contingencies because that's what's required by NERC and by ERCOT. Mr. Donahue finds that the prevalence of new and worsened system operating limit violations without San Miguel increases. Now, Mr. Guerrero said that the appealers have noted and object to Mr. Donahue's opinions in part because under normal operating conditions, taking San Miguel offline doesn't make a difference. As Mr. Donahue has explained, that's an overly simplistic way to look at this problem. Contingency analysis is a critical part of evaluating system reliability under NERC and ERCOT standards. So applying his experience as a system planner, Mr. Donahue looked at the range of situations that he would have looked at in that role of ERCOT. The appealers also note in their motion that there are certain conditions where taking San Miguel offline might actually improve matters. And while there are some areas where those conditions do happen, Mr. Donahue has examined the results of this analysis in aggregate and applied his experience to conclude that there is a reliability need for San Miguel. Mr. Donahue is entitled to apply his experience and expertise and use that as a basis for forming his opinions. Texas courts have repeatedly found that experience alone may be a sufficient basis for expert testimony, and as long as the expert has reasonably explained their opinions, there is not an analytical gap that merits disqualification. In the Turbo Canyon case, the 5th District Court of Appeals found that a police officer's testimony was reliable and admissible on the cause of a car accident, where he applied his experience in accident investigation to available facts and reached a conclusion on causation. The situation here is factually analogous, Your Honor. Mr. Donahue has used the available ERCOT model to generate a data set on what the transmission impacts of taking San Miguel offline might be. He has then applied his own experience and expertise to interpret that data set and reach a conclusion. A different interpretation of that modeling data can be offered by the appealers and their experts, but that is grounds for cross-examination and not for disqualification under Texas law. Mr. Guerrero also raised the issue of Mr. Donahue's opinions on the 2020 high wind, low load case. And it is true that Mr. Donahue did not run a model for that 2020 case because one is not available from ERCOT. Instead, Mr. Donahue explained that the violations that he found in the 2023 high wind, low load case are issues that would be most likely solved by the construction of new infrastructure. And in his professional opinion, that new infrastructure was unlikely to be built by 2023. So if we traveled 3 years back in time to 2020, infrastructure that won't be there in 2023 is also unlikely to be there in 2020. I do want to take a moment to specifically address Mr. Guerrero's argument that there is a gap in Mr. Donahue's opinions because he did not try to solve for potential future conditions. Mr. Donahue explained at his deposition that when you make too many changes to these ERCOT models, it renders their results unreliable because it requires you to make assumptions about changes in the grid or how the grid is operated. He also noted that many of the changes that will likely be necessary to resolve the transmission capability issues that he finds in his modeling in the long term are infrastructure improvements that will take years to plan and build. The Peeler's criticism of Mr. Donahue in this regard also misconstrues the nature of his opinion. As we've mentioned, he's offered here to rebut the assertion of the Peeler's expert Bob Fagan that San Miguel could go offline permanently right now with no impacts to the grid. Mr. Fagan has reached that opinion by looking at resource sufficiency, a point which Mr. Donahue does not contest, and then summarily concluding that there would not be transmission impacts. In doing this, Mr. Fagan has relied upon ERCOT reports that examine the need for transmission upgrades when San Miguel is still online. So those reports can't actually offer information about what kinds of transmission improvements would be needed when San Miguel comes offline. In doing that, Mr. Fagan ignores the availability of analytical tools that he acknowledges are regularly used by power system operators and that can actually test what will happen to the grid if San Miguel is taken offline. Mr. Donahue applied these tools and concluded that San Miguel must be online to ensure sufficient transmission capability under current system configurations. Mr. Donahue has not testified that there is no hypothetical set of conditions that could ensure reliability without San Miguel. He's simply saying those conditions don't exist now, and based on ERCOT's own models and his professional experience and how long it takes to site new transmission, they won't exist in the near future. Again, the Peelers can cross-examine Mr. Donahue on this at trial, but it is not a ground for disqualification. Lastly, Your Honor, I'd like to briefly touch upon the lost copy of Mr. Donahue's report. The question here is really whether the Peelers are materially prejudiced by the loss of the paper copy of the report, and they are not. In the Harris County Appraisal District case, the First Appellate District held that the loss of an expert's work file does not create material prejudice when 4 factors are satisfied. The first is that the expert's report and data were timely furnished. Second, the opposing party has the opportunity to fully depose the expert. Third, the opposing party has the right to cross-examination at trial. And fourth, the opposing party has the opportunity to present rebuttal evidence. Mr. Donahue's report and data were furnished to the Peelers. As Mr. Guerrero noted, he questioned Mr. Donahue about the draft at his deposition. Mr. Donahue said that he completed all of his analysis in January, and the changes that he made subsequent to that meeting with Mr. Holcomb were to make the report more understandable to a layperson. They did not change his analysis or the underlying conclusions in that analysis. The Peelers have been provided with all that data, and their experts could look at it. And since the underlying facts that Mr. Donahue relied upon and his analysis were unchanged, there is no material prejudice from his destruction of that copy of the report. Mr. Donahue is an inexperienced expert witness, and the destruction was simply following his company's document retention policies. Your Honor, while not binding upon this court, I would also note that the Federal Rule of Civil Procedure that governs expert reports, Rule 26B, was amended in 2010 to make explicit that draft expert reports are protected from disclosure, largely reflecting the sensibility of the committee that writes the federal rules that draft reports are not fundamental to the facts and data upon which experts rely in formulating their opinions and more go to the impressions of counsel and should be protected by work product. In conclusion, Your Honor, Mr. Donahue's opinions are reliable and they're based on a reliable foundation. He's applied ERCOT's models to examine system reliability. He's applied his experience to interpret those results. And the criticisms that the Peelers have raised are points for cross, not grounds to disqualify him. The Peelers have not been materially prejudiced by the loss of the paper copy of the report, and as a result, we ask you to deny the motion to exclude his testimony. Thank you, Your Honor.
Mr. Guerrero?
Just briefly, Your Honor, I'll note a couple of points. First of all, with respect to the federal, we're just not in federal court right now. I mean, that would be more persuasive if we were in federal court, but we're under the procedure. And again, the case that Ms. Peloso cited involved the inadvertent losing of a work file. Here we have something very different. He went and he spoke with San Miguel's attorneys. He sat in a room with them. He had his report. He made changes to the report based on that conversations, and then he shredded it or somehow destroyed it. That's very different fact pattern than the Harris appraisal district case that they cite in their response. And so we feel that his destruction of that and our lack of discovery as to that draft report, which is allowed under the Texas Rules of Civil Procedure, we feel that that is grounds for exclusion. Next, with respect to Ms. Peloso's argument about what Mr. Donahue's opinion actually is. What she describes to the court is more expansive than what he actually did and what he is opining for. Ms. Peloso talked about how Mr. Donahue leaves room for the fact that there could be some scenario in the future where San Miguel could close if infrastructure was built or something like that. That's not what he states in his report. If I can share my screen briefly again, what he...
Go ahead.
Sorry about that. What Mr. Donahue says in his report is that there's many options that exist to address these violations that he's identified under ERCOT's modeling. And when he's asked about these options that he's acknowledged exist, he's asked, but you and the work that you performed did not look at any options at all, correct? And his answer was, we did not look at those. But based on my 37 years of experience, yes, there are options that could be taken, but I did not do that in this analysis. He didn't perform the analysis that Ms. Peloso was talking about. He didn't look at potential infrastructure. He didn't go over the ERCOT reports to see what was planned. He didn't do any of that work. What he did is only half of the work, only half of the work. He applied the ERCOT model to identify what the violations were, and then he stopped. He did not do any analysis into what ERCOT can do to address those violations, even though he acknowledges that there are things that ERCOT could have done. Again, his opinion that he's offering in this case isn't what Ms. Peloso says. It's not that I leave room for the fact that in the future there might be a condition where San Miguel can be taken offline. What he says is that it must be in service. It must be in service. That is his opinion. And there's an analytical gap that exists there. I'll just cite a couple of cases in closing. As stated in the Robinson case, the Supreme Court's decision, a trial court must assure itself that the proposed expert has not taken a myopic view of an issue by giving too little weight to alternatives. That's exactly what Mr. Donahue has done here. He's only looked at one side of the coin. He's taken a myopic view that in this one particular snapshot, there's a violation in this only one contingency out of 4 that he ran, and then he stopped. And he pretended he imagined that ERCOT didn't exist. He worked at ERCOT. He knows what ERCOT could do. He knows that there's options, but he didn't look at any of that. It's a myopic view, and because of that, it should be excluded. An expert in the Mel Acres Ranch case, another Texas Supreme Court decision, an expert must connect the data relied on and his or her opinion and show how that data is valid support for the opinion reached. We are not required to ignore fatal gaps in an expert's analysis or assertions that are simply incorrect. And lastly, to Ms. Peloso's point that these issues can be addressed at cross-examination from the Gamble case. The trial court's gatekeeping function under 702 does not supplant cross-examination as the traditional and appropriate means of attacking shaky but admissible evidence. But neither does the availability of cross-examination relieve the trial court of its threshold responsibility under 702 of ensuring that an expert's testimony both rests on a reliable foundation and is relevant to the task at hand. The appealers would submit that Mr. Donahue's testimony is not based on a reliable foundation, and as a threshold matter, he should not be allowed to present any testimony to the jury, and that his opinion should be excluded. Thank you, Your Honor.
Okay. All right. And who's going to argue the next motion?
Honor, I'll be defending the motion on behalf of the appealers.
Bob Schick will be arguing our motion to strike, Your Honor.
Clinton Butler will be arguing on behalf of STEC, Your Honor.
And Cody Schneider on behalf of Cubit Mining Group, Your Honor.
Go ahead, sir.
Thank you, Your Honor. This is San Miguel, STEC, and Kiewit's motion to strike proposed exhibits and testimony regarding the cost to remove buried coal ash on the Peeler premises. 2 months ago, Your Honor, on November the 18th, 2020, long after the close of fact and expert discovery, the Peelers attempted to disclose for the first time an entirely new category of damages to the tune of $218 million, 3 times the amount of damages that had been pled, that had been testified to their experts. And all of that for the cost of digging up restored land, removing buried ash, disposing of it in a landfill, and then the required re-restoration of that already restored area. The disclosure that was filed on that day included 3 new exhibits: a proposal and a spreadsheet from an environmental consulting firm known as Newfields, which was dated just a day before the disclosure was made, and a proposal from Waste Management for the construction of a landfill. Mind you, neither of those companies or this work had ever been disclosed. They had not been designated as witnesses nor as expert witnesses. And what this attempted designation and exhibit list is far too late, and it is highly prejudicial to San Miguel, to STEC, and to Kiewit. As this court knows, fact discovery in the case ended over a year ago on December the 17th, 2019. We took 27 fact witness depositions, most of them going the full 6 hours. 800,000 pages of documents were produced. Similarly, expert discovery in this case ended on June the 12th of 2020. 20 depositions were taken. And as this court knows well, we're still arguing about motions to strike those experts. The pleading deadline in the case was November 18, 2019. Motions to disqualify experts also long past, September the 15th of last year. And dispositive motions were due to be filed on October 14, 2020. All that is in the past. As Your Honor is aware, this is not the first time that an attempt has been made to bend the deadlines set by agreement and then ordered by this court. Back in November of 2018, the Peelers attempted to add 25 newly named individual people at the 11th hour before the deadline. And this court ruled in a telephonic conference that the court's order meant what it said. Any added parties have to be both added and served by that deadline. We're here on this motion today, Your Honor, asking the court again to enforce its order. In addition to the enforcement of that order, however, under Texas Rule of Civil Procedure 193.6, the Peelers bear the burden of convincing the court today that they have good cause for this late disclosure, something they don't even address in their response. And they further, under the rule, must show that it does not and will not unfairly surprise or prejudice San Miguel, STEC, and Kiewit. They can establish neither prong. Is there good cause? The court may remember that it was back on March the 3rd of 2020 that you ruled from the bench, Your Honor, that ash from lignite mined from other leases could not, under the terms of the lease as you understood them, be buried on Peeler property. If there was ever a reason for the Peelers to have felt emboldened to add this new damage claim, that would have been it. But they didn't. And they waited 8 months after that court ruling from the bench to add this disclosure. Moreover, their own expert on damages and they only have one expert on damages, is Carl Killian. He produced a supplemental report to his original report 2 months after that court ruling on May the 11th of 2020. He makes no claim, no assertion that an additional amount of damages should be owed to the peelers with respect to buried ash. In addition, I took his deposition on May the 19th of 2020. And not only, Your Honor, did he not assert any claim of damage for the removal of already buried ash, he actually testified that the peelers ought to be compensated for the cost of disposing what ash remains unburied and placing it in the final pit on the property and covering it with 10 feet of subsurface soil and 1 foot of topsoil, which is exactly what the San Miguel has been doing throughout its reclamation period. And this, by the way, that remaining ash that is still above the surface is the only ash which might include ash from non-peeler lignite. Mr. Killian makes no claim, made no claim at any point in his report or in his deposition for the removal of buried ash or what those costs would be. I want to show you a couple of excerpts from that deposition, and we'll share this screen, Judge. I asked him, so none of your calculations or recommendations from Burgess, and by the way, Judge, Burgess is one of the other peeler experts, include having to dig up and haul off ash that's already been disposed of and covered up on the peeler property. Is that correct? That's my understanding. That's correct. We go to the second. And I asked him, let's go to page 15 of Appendix B. This is of his report, Your Honor. And this slide deals with the actual closure of ramp pit 10, and that's the final pit that's on the peeler property. After water has been removed, which was on page 14, and I skipped, and ash is placed into the bottom of the pit, correct? That's correct. So their own expert is saying, take this ash and bury it in the bottom of the pit, and whatever cost there is, you've got to pay the peelers for the cost of actually burying ash. He says, and I say, and your first question for Burgess, an expert, and Aqualogic, another of their experts, was whether to install or not a liner, to put a liner at the bottom of the pit. He says, correct. And it looks like the experts who you've been in communication with are at an 8 out of 10 certainty. He did this probabilistic estimate, Judge, that no liner is going to be installed, correct? Correct. Okay, and again, once that is in place, you install a soil cap across the 38 acres and then place 10 feet of selective hullback soil on top. That's correct. And let's go to the last one, Tony. And then I ask him, this analysis assumes exposed ash, what's there now, adjacent to pit 10, will be disposed of in ramp pit 10. And that's what these 3 slides of his report do, correct? His answer, correct. So no other expert, not only not Killian, not even the other experts who the peelers have designated and who've been presented for their depositions and whose reports have been produced, ever suggest that the removal of ash is required or mandated under the lease. Instead, they all agreed, as Killian did with his input, that you bury the ash and you cover it with subsoil until you get to within 1 foot of the surface, and then you use a foot of topsoil. Had the peelers wanted to assert this new claim for $200 million, there is no reason they could not have done so within the deadlines. The response, Judge, that was filed by the peelers offers no reason for this delay. It offers no good cause for the delay. Moreover, at no time did the peelers seek leave of court for ignoring that deadline. The peelers' written submissions to the court have also disclaimed any intent to seek this category of damages. The court may be aware that San Miguel filed a motion to reconsider your honor's ruling on the summary judgment with respect to the claim that it breached the lease by disposing of coal ash. It came from lignite mined outside Peeler property. We filed that motion to reconsider, and the Peelers have responded. In that response, which by the way, was filed on July the 14th, the Peelers said that they are not making a claim under the lease for any harm from burying coal ash. If we could look at this. This is from page 2 of their response to our motion for reconsideration, Judge. And what the Peelers said was, furthermore, San Miguel is wrong that the Peelers' contractual claims require proof of injury from off-site coal disposal. The Peelers have plainly stated that disposal of off-site coal ash comprises the torts of negligence and trespass, but is not in and of itself a contractual violation because no lease provision expressly bars introduction of toxic waste to the ranch. Now that quote, Your Honor, is interesting for two reasons. One, because it suggests that they weren't being truthful with the judge when they said that the contract does not permit the burial of non-Peeler lignite ash on Peeler property. But more importantly, what they are saying is that there is no injury. There's no need for us to show injury. And indeed, at that point, they hadn't. Let's go on to the second one. Instead, Your Honor, what's been very clear throughout all these pleadings is what they're really after is an appropriate item of damages claim. What they're really after is this. Smecky's decision to dispose of off-site coal ash on the Peeler Ranch has delayed reclamation of the Peeler premises for decades. That's what they're claiming. And that's what they claimed throughout. And it is a legitimate source of a damage complaint. And in fact, Killian, through his report and his testimony, says that San Miguel owes the Peelers for loss of use of that surface acreage that has not yet been restored and turned over to them. Let's look at the next slide. On page 17 and 18 of that same reply, they say that one of the methods by which San Miguel failed to comply with the lease requirements for reclamation is by disposing of off-site ash on the Peeler Ranch. Because such disposal unnecessarily delayed reclamation, it contributed to San Miguel's violation of its express contractual, next page, duty to timely reclaim the mined areas. That's really what this was about, Your Honor. And it was never about, and they disclaimed repeatedly, any attempt to seek damages for wholesale removal of that ash from restored property. And they say that the Peeler's relevant breach of contract claim is for failure to reclaim. And it's injury from failure to reclaim which is required for this contractual claim to survive. That's what they've argued. And I'd like to point one other thing out to the court on page 3 of this very same response filed July the 14th. In the context of what we're arguing here, Your Honor, that the deadlines mean what the deadlines stand for. What's sauce for the goose is sauce for the gander. And what the Peelers Council argued in this motion was that San Miguel's motion for leave to amend its answer for a fourth time. And by the way, I'll add, they're responding to our motion to reconsider your ruling on ash disposal. In that motion for reconsideration, Your Honor, we ask you, and it's set for hearing in February, we ask you to reconsider your ruling. But in the event that you do not, we're asking you to allow us to make 2 additional affirmative defenses that had not been raised previously. That's what they're referring to here, to add 2 new affirmative defenses 8 months after the court-ordered deadline for such amendments should be denied. both because it prejudices the peelers to be forced to rebut newly raised defenses without the benefit of discovery focused on these issues, and because San Miguel has provided no reason why this court should toss aside its established schedule just so San Miguel can add new legal theories at the 11th hour. I concur entirely, Your Honor, that the schedule is what the schedule is and should not be broken. And they've said it themselves. Indeed, in addition to all this, Your Honor, the Peelers Council in past hearings before this court has echoed explicitly the same assertion that they are making no claim for damages for the burial of Ash. If we could go to the August 24, 2020 hearing. And Ms. Whittle said that because we asked our experts not to require removal of coal ash within the lease boundary, the restoration plan ended up focusing on areas outside the lease boundary. So that cost is for cleanup outside the lease boundary. Well, mind you, Judge, nobody is accusing San Miguel of burying ash outside the lease boundary at all. This is a claim with respect to contamination that may have gone outside because of an incident, a discharge of some sort, or water. But there was a good reason that they didn't ask their experts to look at the cost of removal of coal ash, and they did not. Again, when the court was hearing the motion to strike Killian as an expert, and that, Your Honor, heard on November the 2nd of this year, this is what counsel said. They didn't do that because they could not win it. She's talking about why, she said the coal companies really believe their argument that we can't show our costs of remediation are reasonable and necessary, that they, meaning us, should have filed a motion for summary judgment on that issue. They didn't do it because they could not win it in no small part because the peelers are entitled to ask for removal of all the coal ash from their property, and which would be far more expensive. They could have, they're entitled to, she suggested, but they didn't. And they didn't for good reason, because at that point, all the experts have testified, all the experts have finished their reports. They didn't ask their experts to look at the cost for removal of ash, and they're doing this now at the 11th hour. Thank you, Tony. There is no good cause for this late amendment or disruption of the scheduling order of the court. And it does indeed create unfair surprise and undue prejudice to San Miguel, to Steck, and to Kiewit. Discovery in this case, Your Honor, has already exceeded in scope anything I have seen in 39 years of practice. Allowing this will necessitate more discovery and the inevitable motion practice that this case seems uniquely able to spawn. Indeed, the peelers in their response are already asking the court for discovery on a side issue of their own creation. Remember that I told you that one of the exhibits they offered in this new disclosure on November 18 was a letter from the environmental consulting firm Newfields with a suggested estimate of costs. Of course, that letter's hearsay. That expert was, or that individual who signed that letter was never designated as a witness, never designated as an expert. And Peeler Counsel knew that Newfields, a different person with Newfields, was working for San Miguel on a consulting basis with respect to the retrofitting of the 2 ash ponds and equalization pond on the plant property, which we've talked about previously. So that's a Newfields person consulting on how are you going to reline the pits, what kind of a liner are you going to use, etc. And now here is this letter coming in from another Newfields person for the peelers estimating a cost. So we did at Vincent and Elkins call Newfields, not this individual, but we called Newfields and said, doesn't this cause a conflict for you all? We never spoke with any individual involved in this letter, and Mr. Killian submitted an affidavit and says he talked to a Mr. Gobb, and we never spoke to Mr. Gobb, and we never spoke to the person who authored this particular report. And it was on their own that the author of the report withdrew it. Peeler's counsel, in their response, spend half of the responsive brief, complaining and accusing my law firm of ham-handedly coercing and interfering with these individuals and asking for discovery as to that supposed interference. So here we are off on another rabbit trail that has nothing to do with an issue in front of this jury. And indeed, it is absurd to ask for such discovery, Judge, because it's putting the cart before the horse. It has nothing to do with establishing good cause to, at the 11th hour, triple the damage claims that have been asserted in the case. And that's the issue before this court. They also make reference to the fact that they expect us to supplement our discovery as to what that consulting individual with Newfields was doing with respect to the ash ponds. And we have complied. First, there was a public meeting held with respect to what kind of work San Miguel intended to do on those ash ponds on the property it owns. And council attended that meeting. In addition, we have produced 522 documents to update what's gone on with respect to that work. The second exhibit that they attempted to put on their exhibit list on November the 18th, Judge, came from Waste Management. That also is inadmissible hearsay. The report's hearsay. Waste Management has never been designated as witness or as expert. And it also was created toward the end of November of last year. Second, those are the exhibits. Second, they offer testimony now for the first time from Alonzo and Jason Peeler and say they're going to testify about these $218 million costs. Well, we all know that that Alonzo and Jason Peeler are not experts. They are not entitled to rely on hearsay. Texas law also is clear, Your Honor, that while landowners are able to testify about value of their property, and we all know that, it's equally clear that landowners may not testify or prove up costs of repair estimates or repair costs. And we cite numerous cases at page 9 of our motion, Judge. It is akin to one of the examples you've raised in the past, Your Honor, has been the car and getting an estimate as to how much is it going to cost to repair my car. Well, I, as the owner of the car, can't walk into court and say, this is what it's going to cost to repair my car. I'm not a car mechanic. I don't specialize in collision repair. So I can't testify that those are reasonable, necessary costs. But that's precisely what the Peelers Council is attempting to shoehorn into this case through Alonzo and Jason Peeler, suggesting that they can testify to a cost estimate of $218 million. In the executive taxi versus Abdullah case out of the Texas court in 2004, the Court of Appeals held that a project estimate without the testimony of the person making that estimate or other competent testimony is no evidence of damages because the estimate is insufficient to establish the necessity and reasonableness of the repairs. Moreover, Your Honor, the Peelers themselves disclaimed any knowledge even of the value of their property when we took their depositions, let alone an ability to testify as to the details of any sort of reclamation. And indeed, neither Jason nor Alonzo Peeler were designated or disclosed for the purpose of testifying as to ash removal costs. But just so you get a sense, they even disclaimed the ability to testify as the value of their own property. We'll take a look at a couple of deposition excerpts. This is from Jason's deposition taken in October of 2019. On page 49, I asked him, do you know what the market value is of that 25,000 acres? His answer, no. Next excerpt. I said, okay, if you're going to give an opinion, how are you going to go about figuring out what the market value of the property is? Answer, it's just an opinion. I don't know. And he then says, I haven't thought about it. Sorry, I don't know. Let's go to the next excerpt. I say, you don't know what the market value is? No, is that correct? You do not know what the market value is as we sit here today. It hasn't been sold in 113 years. There's no market value that we can tell. Then go on to the next one. Do you have an opinion as to the value of the buffer zone? That's 900 acres. His answer, no. So Jason Peeler disclaims any ability to testify as of the date of his deposition without supplement of any kind, his ability to testify even as to value of the property. Now let's look at Alonzo Peeler's deposition on page 19. He was asked, what is the value of that piece of property? His answer, I'm not an appraiser. I don't know. I can't give you a good answer. Those were their answers, Your Honor. They couldn't testify even as to the value of their property. To allow this additional claim to triple the damages after the scheduling order has foreclosed it constitutes unfair surprise and a violation of this court's order and is prejudicial. Moreover, Judge, I would simply ask, where does this end? We have a schedule for a reason, and we have deadlines for a reason. And you know that this case has created an awful lot of paper and back and forth among the parties. It is unfortunate, but it is where we are in this litigation. And if the court were to allow this, we are going to have to engage in additional discovery. For example, I'm going to have to depose the Peelers. I'm going to have to redepose Mr. Killian, much as I don't want to, because I don't think he's got admissible testimony at the moment to prove up any of these additional damages. But I would be forced to take his deposition and the depositions of these other experts who, by virtue of the response filed, Ms. Whittle suggests may have some additional testimony to offer as well. And then there are others that we may want or that Ms. Whittle and the other counsel representing the Peelers may want. And then, of course, come the inevitable motions in connection with those depositions. And you know, Your Honor, from the history of this case, there will be such motions just both before the depositions take place and after. The response filed onto this motion suggests that, well, these damages are relevant for punitive damages purposes. That's illogical. We all know that net worth evidence is relevant when it comes to an argument for exemplary damages. However, in this case, the Peelers hired an expert to testify that the net value, the net worth of San Miguel is actually negative. So they couldn't do any good on exemplary damages proof that way. But this does not constitute net worth. This is just an inflated damage figure for purposes of putting a big number in front of the jury. It's not net worth. I mean, there's no stopping. Why not, instead of just saying, dig up the ash that's already been buried and then put a bunch of other soil in and create a landfill, why not just say, we're going to scrape off 6,000 acres, everything, and we'll run the number up to $1.5 billion and see what the jury does with that. This is not admissible proof with respect to exemplary damages. Second, they say, well, it's relevant because we're seeking injunctive relief. Well, that's different from breach of contract damages. First of all, injunctive relief, cost is irrelevant when it comes to injunctive relief. And as Ms. Whittle mentioned before we got started on the Donahue motion, an injunctive relief is for the court. There's no question for the jury on that. There's no need to put any of this in front of a jury. But in addition to that, Your Honor doesn't care about the cost. You're going to, if they're going to ask you, Judge, fashion a judgment, incorporate whatever verdict the jury has come up with, and we want you to enjoin the parties and enjoin San Miguel and require them to remove ash. What it costs has nothing to do with anything. You're going to make a legal determination based on contract and statutory language. Finally, they mentioned the economic feasibility involved here. Well, The value of this entire 25,000 acre ranch, according to their own expert, Mr. Bolton, who you've also heard about, is $50 million. What possible sense does it make to spend 218 million, 4.5 times the full value of an unimpaired ranch, which is what Mr. Bolton came up with? There is no good cause for this light designation or disclosure or exhibits. It is prejudicial. There will be no end, Judge, to the discovery and the motion practice that these parties are able in their imaginations to manufacture. We ask the court to enforce its scheduling order to strike this light disclosure and the exhibits and the proposed testimony offered at that time.
All right, Mr. Schneider?
Yes, Your Honor. Thank you. Just to bring it back to the big picture, this is $200 million that we're talking about here. $200 million. And it's all based off of two estimates, both that were disclosed for the very first time a year after fact discovery closed and about 6 months after all discovery closed. Moreover, to prop up these two estimates, the peelers don't offer any testimony from the companies themselves. And as Mr. Schick just mentioned, one of the companies has just withdrawn that estimate. And they also do not offer any testimony from an expert. Instead, the peelers want to offer up Alonzo and Jason Peeler to testify to these two estimates. However, Alonzo and Jason Peeler aren't qualified to testify about these estimates. One, they're from other companies and it's hearsay. And two, they're not experts with respect to the cost of removing coal ash. The peelers claim that Alonzo and Jason Peeler have decades of experience in land management, including cost of moving soil, and Jason Peeler owns a trucking company, so that makes them qualified. Land management, moving soil is not the same thing as excavating coal ash and constructing landfill for the relocation of coal ash. It's highly technical and specialized. They don't have the expertise of it. Simple as that. Moreover, these alleged opinions that are going to be offered by Alonzo and Jason Peeler, they're not based off their personal knowledge. So it's not admissible under Texas Rule of Evidence 701. That's because neither Jason nor Alonzo Peeler were the ones that sought out, investigated, or obtained these estimates. It was Carl Killian. So they don't have personal knowledge of this. And that's important because that makes this situation with the peelers different than the cases cited by the peelers for when a party could potentially offer testimony about estimates. In those situations, in those cases, the plaintiffs themselves or the party that is trying to prove up those estimates are the ones that familiarize themselves with the cost of the repairs. They went out to the contractors, they investigated other people, they familiarized themselves with it. That is not what Jason and Alonzo Peeler did here. Instead, this is more of a situation like Anthony Equipment Corporation versus Irwin Steel Erectors. In that case, Your Honor, that's where a plaintiff, a steel erection company, tried to offer testimony about an estimate that they received and obtained for crane repairs. And it was based off an estimate that the plaintiffs rejected, and they did the repairs themselves. But yet they tried to use that and prop that as the basis for their damage model. However, the court rightfully found that they weren't qualified as experts to offer that testimony, because although they might have been in the steel erection company business, they weren't in the business of crane repairs. And moreover, it wasn't based off of their personal knowledge of familiarizing themselves with other costs of repairs, investigating what might be reasonable costs. It was just based off of an estimate that they rejected. And these estimates here, especially the one that's already been withdrawn, won't be used to do the actual coal ash removal. Moreover, Your Honor, the peelers falsely claim in their response that the peelers were never asked any questions about these damages. And I'll share my screen real quick. And if Your Honor, can you see my screen?
Yes.
This is during Jason Peeler's deposition. He's asked, I'll show you what's been marked as 230. It's a paragraph taken from the first amended counterclaim petition. And it's regarding the repair damages right here, Your Honor, repair damages, the cost of and expense of restoring the property to its former condition. And he was asked, do you know what the total amount of money it's going to be claiming to repair damages for the cost and expense of restoring your property? No. So he was asked about it. Do you know whether somebody is working on calculating that? No. Do you know how much of the property is going to need the repairs? Out of the approximate 6,000 acres leased by San Miguel, he doesn't know. So he was asked the questions, Your Honor. And he told during his deposition that he simply did not know. Moreover, with respect to the peeler's claims that this is not a new damage model, quite frankly, that's preposterous. They claim that a general statement from their second amended disclosures that Jason and Alonzo Peeler would testify about other economic damages allows them to now provide testimony to $200 million of coal ash. And I'll just share my screen again. This is what they're talking about. This is Exhibit 4 to the Peeler's response. And it's this statement here, that Alonzo and Jason Peeler would testify regarding the declined fair market value and other economic damages to the Peelers related to the contamination of the Peeler Ranch. Now, what you'll notice is what they try to squeeze in later on is this right here. These economic damages also include the cost of coal ash removal, disposal of landfill construction, and former disposal pit and landfill restoration in the formerly mined areas for approximately $218 million. And again, they still state this highlighted area right here, that there's other economic damages to the Peelers related to this contamination. So the question bears itself, if that generalized statement right there is enough to leave the door open for $200 million worth of damages to be added a year after fact discovery is closed, 6 months after all discovery closed, when does it end? Does it mean they're always open to amending more for another $100 million, another $200 million, $300 million? Where does it end? It should end when the docket control order says it ended. And that's long past, Your Honor. And Mr. Schick went into great detail about this, so I won't belabor the point. If that generalized statement that's still contained within their disclosure statements allows them to constantly change their damage model, which it becomes pretty obvious the reason they're doing it here is because they're seeing that the timely disclosed one is flawed. So they want to change it to add something else they think they can squeeze in. Well, if they then decide this one's flawed, they want to add another one, where does it stop? Where does discovery end? Where does the motion practice end? The Peelers should not be entitled to open up a can of worms for this case to cause continuous and additional litigation. It has to stop when the order said it stopped, and it's passed. And it's for these reasons, Your Honor, we ask for the court to strike this coal ash removal damage model, Your Honor. Thank you.
All right. Mr. Butler?
Thank you, Your Honor. Hewitt and San Miguel have done a really good job of presenting the fact that there's not good cause to allow this to move forward and the prejudice that it would cause to San Miguel, Hewitt, and Steck. And so I'm not going to belabor that point. I do want to make one general point as to all of the defendants and then one that's specific just to Steck. With regards to bringing in this testimony by and through the Peelers, that seemingly violates just about every tenet of expert testimony possible. And I would refer this court, I know this court has a lot of history with the Mustang Pipeline case, and so I just cite this court directly to the Mustang Pipeline case, particularly that portion. Let me see if I can just screen share right here. A party seeking to recover the cost of completion in a breach of contract case, which is basically what this is. You know, the repair costs are what it would take allegedly from the Peelers to complete what they believe is the damages that would be owed to them, or the repair damages owed to them in order for the parties to be able to complete the mining lease. They have the burden to prove that those damages are reasonable. And evidence of amounts charged or paid standing alone is no evidence that such a payment is either reasonable or necessary. And in the Mustang Pipeline case, Mustang directed the court to expert testimony. They had expert testimony establishing what the damages would be, but that alone, just expert testimony saying, here's what the cost of repair would be. That alone does not establish reasonableness. And the court said that you've got to have something more than just these are the amounts paid or the amounts charged to be able to establish reasonableness. And that was buying through expert testimony. And in this case, we don't even have expert testimony establishing reasonableness. All we have are several invoices or proposals, bids, one of which has been disclaimed by one of the bidders. So there certainly can't be reasonableness as to the Newfield bid, because Newfield themselves has informed the court buying through an affidavit, we don't believe this is reasonable. And so certainly any establishment of reasonableness of these repair damages in the amount of $200 and whatever million is going to need expert testimony. And I think this court would agree the last thing this case needs is more experts. The last thing we need is to bring in additional experts, just open the door wide open to discovery again, get the deposition testimony of their experts, get our rebuttal experts, do the depositions of both those, swap Robinson motions on everyone. We're just way too late in the game for us to be able to do that. And this is coming from a firm that got into this game late. We came into this game late, and we didn't seek to throw open the doors of discovery by saying, look, Stack has changed horses midstream, and therefore, we need to be able to reestablish our defense. We understood the game that we entered when we came in, and we understood the rules that we were subject to. We understood the discovery had closed. We understood that, we are at where we are at, and we have modeled our defense around that. Had we known that, at any time we feel like it, we can, throw open the doors of discovery, we probably would have done so. But as to Stack individually, and certainly I don't want to create any distance between me and my client and the other defendants in this case. We are, locked arm in arm as far as our defense in this. But as to Stack individually, these damages are based upon the mining lease. This court has already granted a motion for summary judgment in favor of Stack. We're not liable under the mining lease. So as it leads to Stack, even if this court was to get beyond the evidentiary, procedural, and substantive issues that my co-counsels have raised, and the lack of good cause, the volumes of prejudice that would come along with this, even if you get past all that somehow, Your Honor, with regards to Stack and Stack alone, we cannot be subject to this because this is a breach of contract claim. And you have already ruled, pursuant to your motions for our motions for summary judgment and the cross motions filed by opposing counsel, you've already ruled that we are not liable under the buffer or the mineral lease. And therefore, we could not be subject to this damage model, which rests under the mining lease. And so, Your Honor, we ask that, globally, that this be struck as requested by San Miguel and Kiewit previously. But even if you were to deny the striking as to San Miguel and Kiewit and found that there's an evidentiary, substantive, and procedural basis to move forward with this testimony, at least as to Stack, we would ask that you strike it because we're not liable under any contract, mineral lease or buffer zone, pursuant to your previous rulings. And with that, we'll reserve the rest of our time for rebuttal, Your Honor.
All right, Ms. Whittle, Mr. Guerrero, who's going to?
I'll be arguing for the Peelers, Your Honor.
Go ahead.
Your Honor, this is a motion to exclude 2 exhibits from trial and any testimony regarding those exhibits. Throughout this litigation, the Peelers have sought both injunctive relief and specific performance related to removal of the ash. Both are clearly pled, and I'll go through our pleading, Your Honor. At paragraph 10 of our third amended counterclaim petition, we state that the Peelers seek a mandatory injunction requiring cleanup of the contamination and restoration of the property that results at a minimum in, number 2, the complete removal of coal ash and other solid and hazardous waste disposed in and on the Peeler Ranch. Then at paragraph 240, under our breach of contract cause of action, we say to remedy San Miguel and Steck's breaches, the peelers are entitled to specific performance of the lease provisions, including immediate commencement of full reclamation and restoration of the damaged areas of the Peeler Ranch. And we state this necessarily will require the complete removal of any and all coal ash and any other solid or hazardous waste, which were placed in a manner inconsistent with the lease provisions. Then at paragraph 305, we state again, our application for mandatory injunctive relief, which includes the complete removal of coal ash and other solid or hazardous waste disposed in and on the Peeler Ranch. And at paragraph 316B, we have in our prayer, again, a request for a mandatory injunction, including the complete removal of coal ash. And I think it's worth noting, as Mr. Butler just argued, injunctive relief or specific performance under the contract does not apply to Steck and Kiewit because they are not parties to the contract. And we have already agreed with Kiewit that we are not requesting injunctive relief against that party. So their objections, aren't really well founded as against their clients. Although the restoration plan designed by the Peelers remediation expert, Gordon Johnson, and costed out by Mr. Killian for the purposes of calculating an award of actual damages for harm to real property, does not include removal of the ash, and that remains unchanged. Evidence of the cost of ash removal is relevant and necessary for the court and jury's determinations on multiple other contested issues, including their claim for exemplary damages and the reasonableness of the cleanup they seek. Such damages have never been disclaimed by the Peelers. Two of the three exhibits the coal companies seek to exclude are cost estimates for such work provided by the Peelers by Newfields, one of San Miguel's own contractors. The coal companies also seek to broadly limit the testimony of the Peelers with respect to these cost estimates, but their argument is unsupported by Texas law. Nowhere in the coal companies' motion do they contend that such evidence is not relevant, because it is clearly relevant to the issues involved in the lawsuit. The coal companies' motion is nothing more than a blatant attempt to exclude unfavorable evidence they view regarding the substantial scale of the problems they created, and their motion should be denied. From the outset of the lawsuit, the removal of ash and or ash removal costs have been at issue in this lawsuit, and they remain at issue. As clearly pled in the current pleading, which I've just gone through with the court, the Peelers seek injunctive relief requiring cleanup of the contamination and restoration of the property that includes at a minimum the complete removal of coal ash and other solid or hazardous waste disposed in and on the Peeler Ranch. The quantification of the cost of such removal is relevant to the court's consideration of the appropriate injunctive relief. In addition, the Peelers have pled that the coal company's trespasses are permanent and have alternately pled that the trespasses are temporary. The Texas Supreme Court has held the general rule in cases involving injury to real property is that the proper measure of damages is the cost to restore or replace, plus the loss of use for temporary injury and loss in fair market value for permanent injury. The court has also recognized the so-called economic feasibility exception to the general rule, that the cost to restore is the proper measure of damages. The court in Wheeler versus Enbridge Pipelines explained that this exception applies when the cost of required repairs or restoration exceeds the diminution in the property's market value to such a disproportionately high degree that the repairs are no longer economically feasible. In those circumstances, a temporary injury is deemed permanent, and the damages are awarded for loss in fair market value. While questions regarding the facts that underline the temporary versus permanent distinction must be resolved by the jury upon proper request, Whether an injury is temporary or permanent and the damages that flow from that determination is a question of law for the court to decide, relying upon the definitions provided by the court in Wheeler. To date, the court has not determined whether the trespasses are permanent or temporary. To the extent the court determines that such trespasses are permanent, the peeler's trespass damages may be limited to a recovery of loss in fair market value, which is $36 million or about $2 million more, than the special commissioners assessed, $2 million less than the special commissioners assessed in the value of the taking in the condemnation case. To the extent the peeler's damages are so limited, then they have to accept continued possession of contaminated property with a permanent solid waste disposal site. Evidence related to the extent of damages that continue to accrue to the peeler property are relevant as to whether injunctive relief is warranted. One such measure the court may consider is the cost of ash removal. Also, knowing what it would cost to remove the landfill, the ash the coal companies have unlawfully disposed on the Peeler Ranch puts the loss of fair market value into context. I understand counsel purported surprise at the hearing on the motion to exclude Peeler appraisal expert David Bolton, surprised by Mr. Bolton's appraisal of the loss of fair market value. But that loss of fair market value is dwarfed by what it would cost to undo the disposal of 18 million tons of coal ash that will serve as a permanent source of contamination to the ranch. So it supports Mr. Bolton's expert appraisal opinion. In fact, the cost of Mr. Johnson's restoration plan plus the loss of fair market value is dwarfed by the cost of removal of the ash, which provides context for the court in deciding whether an award of damages plus an injunction is warranted. I understand the court has expressed concern about how future reclamation obligations fit in, but the peeler's restoration plan does not involve the property subject to those obligations. It is focused on the property harmed outside the mine permit boundary. And I find it fascinating that everyone is currently worried about a windfall to the peelers when right now they are sitting on a loser, property that has no value and is actually an albatross around their necks, with no guarantee that San Miguel is going to live up to the obligations it so far has not lived up to and has actively flouted. In any event, as part of the peeler's breach of contract claims, they have sought specific performance under the mineral lease, including immediate commencement of full reclamation and restoration of the damaged areas of the Peeler Ranch. And as stated at their petition at paragraph 240, specific performance necessarily will require the complete removal of any and all coal ash and other solid or hazardous waste, which were placed in a manner inconsistent with the lease provisions and contrary to the implied easement of reasonable surface use, and have caused widespread contamination. The coal companies argue confusingly that the peeler's position regarding whether unlawful off-lease ash disposal is a breach of contract or a tort somehow disclaimed their claims for removal of the ash. This court has determined that misuse of the Peeler Ranch within the lease boundary is a breach of contract and therefore dismissed the tort claims pursuant to the economic loss rule. While the peelers have asked the court to reconsider that ruling, since the economic loss rule has never been applied to claims for harm to real property, the peelers are entitled to removal of the ash under contract or tort, whether through specific performance under the lease or an injunction for ongoing harm. They have never disclaimed those claims, which remain in the live pleading and were disclosed from the outset of the case. The cost of ash removal is also relevant to the jury's analysis of the reasonableness of the peeler's cleanup and restoration proposal for the purposes of calculating damages for harm to real property. In contrast to the estimates of costs to remove all ash placed on the Peeler Ranch, as set forth in the Newfields and Waste Management estimates, the proposal set forth in Mr. Killian's report, which relies on recommendations from Mr. Johnson, contemplates removal of only a fraction of the ash on the Peeler Ranch. Evidence of the cost of the removal of the ash, of all ash, can be considered by the jury and the court to determine whether the proposal set forth in Mr. Killian's report is reasonable and appropriate, given the scale of the damages. Furthermore, the cost of ash removal is relevant to the jury's determination of both entitlement to and amount of exemplary damages, which is awarded as a penalty or by way of punishment. As referenced previously in hearings before the court, a jury may consider the economic benefit or costs avoided by parties, such as removal of coal ash by the coal companies in the present case, when determining exemplary damages. Similarly, regulatory agencies use economic benefit and costs avoided to assess civil penalties. EPA's policy on civil penalties explains that penalties should, at a minimum, remove any significant economic benefits resulting from failure to comply with the law. And both deterrence and fundamental fairness requires that the penalty include an additional amount to ensure that the violator is economically worse off than if it had obeyed the law. TCEQ also includes in its assessment of penalties both the economic benefit derived from failure to comply with TCEQ rules or regulations and avoided costs. There's no question that San Miguel has avoided the cost of removing the ash and properly disposing of it in a permitted landfill, and that San Miguel has benefited economically by disposing of its ash on the Peeler Ranch, which was not allowed under the mineral lease. Therefore, the removing and landfilling the ash is relevant to an award of exemplary damages. At the first hearing on the temporary restraining order in August 2018, I told this court that peelers seek full excavation of all the coal combustion residuals. It is acres and acres of millions of tons of ash removed from the site and placed in a permanent dry coal ash landfill. The coal companies understood this and requested a delayed trial date because, quote, this case is too complex, arguing hyperbolically that, quote, this dispute involves between 35 billion and 150 billion in damages. One of San Miguel's attorneys was even recognized by Law 360 as a rising star for defending San Miguel against what was described by the attorney as a $1 billion property damage claim. Clearly, the coal companies were on notice of both the amount in dispute and the claims for ash removal. They cannot possibly suggest this is all new. Moreover, in the peeler's second amended disclosures served on January 31st, 2020, at the beginning of the year, the peelers disclosed that Alonzo Peeler Jr. and Jason Peeler would testify regarding economic damages to the peelers related to contamination on the Peeler Ranch and exemplary damages. Alonzo Peeler Jr. and Jason Peeler were both deposed by the coal companies prior to their disclosures, and the coal companies failed to ask any questions regarding damages other than Jason Peeler regarding the market value of the Peeler Ranch. The coal companies did not request any additional depositions of the peelers after they were disclosed to testify as to damages. The depositions that Mr. Schick quoted were from August and September 2019, well before the expert disclosure deadline. They had not yet developed their opinions, which we disclosed in January 2020. The fact that the coal companies failed to undertake any new discovery on the issue after that disclosure does not render the claims for removal of ash new. In fact, the court may recall at the recent hearing on the motion to exclude Carl Killian, I reiterated that the peelers are entitled to ask for removal of all the coal ash from their property, arguing that the restoration damages quantified by Mr. Killian were reasonable and necessary because they are far lower than the cost of ash removal and landfilling would be. And Your Honor, I'd like to also show you testimony or argument from both me and Mr. Schick right after our disclosures. Here, Your Honor, this was an argument regarding a motion to quash the San Miguel corporate representative deposition. And I noted this was right after our disclosures were issued. Our experts estimate that it will cost approximately $100 million to clean up the ranch. That doesn't include removal of the coal ash. That includes keeping it buried on the ranch and creating a capped landfill, taking the groundwater away from those areas of disposal in treating the soils. I do not say that we are getting rid of our specific performance or injunctive relief claims. And then at Here, Your Honor, I state again, here, as I've mentioned, our experts believe it will cost $100 million to clean up the ranch. That's not to clean it up to the way it was before, but just to clean it up to where somebody could actually use the ranch. Now it would still remain an industrial waste site. And then Mr. Schick stated, recall, Judge, that in August of 2018, when this case was initiated, Ms. Whittle, counsel for the Peelers, told the court that it was $1 billion lawsuit. Now we know, as of the expert reports that were filed on Friday, that they are claiming in the neighborhood of $140 million. They concede it is a valuable lawsuit, and they concede that it is a very complex lawsuit. The coal companies argue that the Peelers cannot testify as to ash removal and landfilling costs because a homeowner cannot testify as to the cost of repairs when those repairs were technical or specialized in nature. The case on which they rely involved a plaintiff's estimate of a whole house renovation based on his own calculations without any foundation as to how this estimate was calculated or what the basis of his estimate was. But the exhibits the coal companies seek to exclude provide the exact foundation that the plaintiffs in that case lacked, as do other publicly available documents describing the cost of ash removal and landfilling on which the Peelers may rely.
And what are those what's the basis for the Peelers' testimony, Peelers' opinions?
The Peelers have decades of experience in land management, Your Honor, including in the cost of moving soil. And Jason Peeler owns a trucking company, making them well qualified to testify as to such costs. There are also publicly available documents on cost of removal of coal ash and landfilling that are have been generated by Duke Energy and other companies in the Southeast who've been required to excavate and landfill all of their coal ash. So those unit costs are publicly available and can be relied on by the Peelers.
Isn't that a bit like a cement contractor who does sidewalks and slabs for houses saying, I can opine on what a new Hoover Dam would cost because it's made out of cement?
Well, part of the reason that we went and asked for additional estimates was so the Peelers could rely on these documents that Mr. Schick is asking to exclude. But the Peelers are very well aware of the cost of removing, of moving dirt, as the Peelers would call it. There are ample cases which support the use of lay testimony regarding the cost of repairs, and we've provided those in our response brief, Your Honor. The court may also recall Kiewit's arguments in defense of its lay expert, Simon Zulu. Kiewit argued at length about how lay witnesses may testify on a myriad of topics and that there is no duty to disclose such opinions. As for the coal company's arguments that the Peelers must present competent evidence that the repairs are necessary and the associated costs are reasonable, the case they cite specifically states that the terms reasonable and necessary are not required. Here, the Peelers' testimony will be buttressed by testimony regarding the necessity of the repairs by experts, including but not limited to Gordon Johnson and Anthony Brown, who can testify as to other coal ash cases in which they have participated where courts have required the removal of coal ash, including all throughout the Southeast United States. The court may be aware the new proposed EPA administrator negotiated such an enforcement action with Duke Energy on behalf of the state of North Carolina, requiring excavation and removal of all Duke Energy's coal ash from the state. Mr. Brown was part of that case and negotiation, and that was disclosed to the coal companies. In addition to all of that, the Peelers will rely on the commercial proposals obtained by Newfields, San Miguel's own contractor, and Waste Management. As the court will recall, during the hearing on the coal company's motions to exclude Mr. Killian, the coal companies strenuously argued that Mr. Killian should have obtained third-party estimates for all costs set forth in his report, and unsuccessfully assailed the reliability of his report for failing to do so. They also complained when Mr. Killian didn't rely solely on San Miguel's contractors for those bids. So the Peelers have obtained third-party estimates for ash removal, including from a contractor selected by San Miguel to perform work at the site. The fact that the coal companies immediately demanded Newfields withdraw its bid based on the untruthful claim that Newfields was not aware of the litigation is troubling. The court should reject the coal companies' arguments characterizing the estimates as unreliable or incompetent, as they are the very type of evidence that the coal companies have previously stated were necessary to support a reliable estimate of costs. And I'll just show the estimates to the court. Your Honor, this is the estimate from Newfields, which is also supported by an Excel spreadsheet. It's quite detailed with quantities, allowances, full cost estimate, contingencies, and indirect. Waste Management's proposal is more of a unit cost proposal, which then the peelers would use to base their testimony off of. And you'll see, Your Honor, the ash pond retrofit plan, that is the whole plan San Miguel wants to rely on and disclosed for their response action, is also 6 pages, just like the estimate provided to the peelers. There are no engineering drawings, no cost estimates. This is it. So this apparently is competent, but what Newfields provided to us is somehow unreliable, even though it's far more detailed. In his affidavit, Ryan Barker from Newfields describes his estimate as a Class 5 estimate, which means it is more likely to be on the low side. His estimate is $219 million for removal and landfilling of the ash unlawfully disposed on the Peeler Ranch. And according to the industry standard cost classification system upon which Mr. Barker appears to rely, a Class 5 estimate has an expected accuracy range from -50% to plus 175%. We have attached that standard as an exhibit to our response. That means that Mr. Barker's estimate for ash removal and landfilling ranges from $109 million, which is the median restoration cost that Mr. Killian calculated, to $383 million, which is 4 times the median cost Mr. Killian calculated. Waste Management provided unit costs that result in an estimate in the upper to mid range of the Newfields estimate, applying the AACE uncertainty range. Given that Mr. Barker admits that his estimate is a Class 5, which is biased on the low side, there's no basis for excluding the estimate as unreliable or unreasonably high. Also, this issue of whether the estimate is unreliable because Mr. Barker did not know the estimate was for the purpose of litigation is nonsense. And that's the whole reason he purported to withdraw it. I'll note that the coal companies did not argue this today, but that is the basis of their motion. If the court reads the motion, that's the whole argument, is that somehow Mr. Barker didn't know this was for the purpose of litigation. As the court will see from the attached affidavit from Carl Killian, Mr. Killian reached out to his friend, the CEO of Newfields, and requested a commercial proposal to aid the peelers in quantifying the costs of the removal of coal ash, disposal of the coal ash, and restoration of the former disposal pits. And I'll just pause here to say this doesn't change Mr. Killian's opinions, which were fully disclosed at all. Mr. Killian was just serving as a go-between for the peelers with his friend. In connection with his request for an estimate from Newfields, and contrary to the coal company's motion, Mr. Killian notified them of the pending litigation and the purpose of the estimate. He also provided a copy of the peelers' first amended answer and counter petition to Newfields as background for the request. The estimate provided by Newfields and at issue in the motion is dated November 17th, 2020. If you compare the background section of the Newfields estimate to paragraphs 11 through 16 of the peelers' first amended answer and counter petition, Mr. Barker appears to have lifted full sentences word from the counter petition. The CEO of Newfields, with whom Mr. Killian corresponded, was aware of the litigation prior to providing the estimate to the peelers. Mr. Barker quoted from our counter petition in the proposal. They knew about the lawsuit. It is false to suggest otherwise. Now, the coal companies go to great lengths to manufacture the fiction that while the peelers' claims for ash removal are a new theory, and that they are untimely disclosed. Yet, while complaining of the peelers' untimely disclosure, which is patently untrue, San Miguel is failing to comply with its own discovery obligations. Mr. Schick went on at length about the goose gander rule, but you may recall at the hearing on the peelers' motion to strike Mark Hemingway last week, counsel for San Miguel recited multiple significant projects that he purports have occurred recently about which the peelers have received essentially no information despite outstanding discovery requests. This includes ongoing work at the plant site and on the peeler ranch directly related to this lawsuit. Notably, these projects include retrofitting of the ash ponds at the plant site that was supposedly to be conducted by GSI. But the only plan we have is that Newfields plan I just showed you, Your Honor. As is evident from the Newfields plan and bid for the work at the ash ponds, which we have attached as Exhibits 1 and 2, significant work was proposed to occur by Newfields. Yet beyond those two exhibits, San Miguel has failed to provide any additional documents related to the Newfields work. No correspondence, no sampling results, no photographs, no engineering drawings of any kind. The only two documents produced prior to this last Friday are a bid and a proposal, and no witness has testified that Newfields is performing the actual work, nor is Newfields or anyone from Newfields on any of San Miguel's disclosures. The same is true for multiple other projects cited by counsel for San Miguel at that hearing. The peelers have no documents produced by San Miguel or other disclosures beyond the testimony about what San Miguel expects to do and what San Miguel's counsel claimed to the court that San Miguel has done. All of that information, engineering drawings, correspondence, sampling results, photographs, maps, all of it is responsive to our ongoing discovery requests. And San Miguel had produced nothing beyond those two documents we attached as Exhibits 1 and 2, which are not even finalized or signed. To the extent the court is inclined to exclude the peelers' evidence related to ash disposal costs, undisclosed evidence related to San Miguel's purported corrective actions should be excluded as well. There can be no question that those have not been disclosed by the deadline. As Mr. Schick laid out, the fact disclosure deadline was over a year ago, and the expert disclosure deadline was last June. Can be no question that San Miguel is attempting to inject entirely new evidence into the case at the last minute, which is what the coal companies are falsely accusing the peelers of doing. The same problems they claim arise from the ash disposal evidence certainly arise from the purported evidence of response actions that San Miguel has withheld. We have no opportunity for discovery on any of those actions, so they should be excluded to avoid prejudice to the peelers. Mr. Sutherland simply testified to the court regarding those actions. They haven't disclosed any of it, and they certainly did not disclose it prior to the expert designation deadline or prior to deposition of their experts. Last Friday, January 15th, 2021 at 3 p.m., San Miguel produced 530 documents with 1,189 pages, with documents created from October 2019 to December 2020, some of which have to do with the response action that San Miguel has attempted to perform regarding the leaking coal ash ponds at the plant this past summer. Many of the most critical documents are from March and April 2020. We've been asking for these documents and were told by counsel for San Miguel that everything had been produced. That clearly was not the case. In particular, the documents reference high-resolution photos taken in April and drone surveys performed in February and June that still have not been produced. Both are responsive to our discovery requests. The documents also reference sampling that was performed that has not been produced and cost estimates for closing the equalization pond, which has also not been produced. The list goes on and on. And just to show how confusing this last production is, Your Honor, You may recall that Mr. Sutherland claimed that their expert Mark Hemingway and GSI were hired by San Miguel to design and perform the response action under the federal coal ash rule for the leaking surface impoundments at the power plant. And today, counsel for San Miguel claims that Newfields designed and performed the response action. But the documents produced suggest that another firm entirely performed the work. So today, sitting here, I have no idea who designed the response action and who performed the work and who is taking professional responsibility for it. I still have no actual engineering drawings. All I have are letters from this one person who works for San Miguel, and I will share some of these with the court. So these are the two documents we had previously, this document and this document. I've lost track. Okay, this document from Newfields and this document are the only two documents that we had received prior to Friday regarding this action at the power plant that Mr. Sutherland told the court about. This additional party, James Merchant and Associates, who is a registered professional engineer in the state of Texas, appears to be the engineer actually taking action on behalf of San Miguel at the power plant. He has engaged in correspondence with TCQ. And yet Newfields has actually, an engineer from Newfields has actually applied his professional engineer stamp. We have no correspondence between GSI or Newfields or Mr. Merchant, and it's impossible to know who actually took these actions. Here's more correspondence that we just received. Again, this correspondence is from April 2020, then October 2020, another certification from November 2020 from Newfields. And this, Your Honor, this is the disclosure we have from San Miguel. This is all we've gotten about Mr. Merchant. He's an environmental engineer. We don't know what he knows about the case or what his relevance is. He hasn't been disclosed as an expert, nor has anyone from Newfields, and certainly not the person who apparently placed his seal on these certifications for the liners. The only person they've disclosed is Mr. Hemingway from GSI, who apparently didn't do this work. And here, Your Honor, there are drawings from October. These are the only two engineering drawings we've received, and they're from October 2019. Here's another one. There's no reason these have not been produced until this week when we complained in our response in the ash removal brief. Sorry. So all we have are these letters from Mr. Merchant, who is a licensed professional engineer in the state of Texas, to TCQ, purporting to submit notice of completion of the work, but who doesn't actually apply his seal certifying the work. The idea that somehow we did not comply with our discovery obligations and should have the ash removal costs excluded is pretty hard to swallow, given San Miguel's failure to produce any of this responsive discovery and expected reliance on these response actions in their defense case. We deposed their expert, Mark Hemingway, in late May and the corporate representative in late July. These documents should have been produced prior to those depositions. San Miguel determined not to depose the peelers again regarding damages, even though we disclosed them as lay opinion experts who would testify as to such costs. We asked the court to deny the coal company's motions to strike. The cost of ash removal and landfilling is relevant to the peelers' live claims for injunctive relief, specific performance, exemplary damages, and a demonstration of reasonableness of actual damages. And the fact that the peelers would offer such testimony was timely disclosed back in January of this year. Thank you.
So are you in agreement that the reports that were produced that are the subject of the San Miguel motion were late produced?
Your Honor, it's our understanding that we don't have to disclose the appealer's lay opinions other than to disclose, and we went beyond that by saying that they would be testifying as to damages, and then no one actually took the opportunity to depose them on that. So I guess that's our position, that we don't think they're late because we didn't have a duty to disclose those opinions. I also think it's very clear that we've been asking from the outset for specific performance and injunctive relief, and any evidence based on exemplary damages, that's not something we have to disclose either.
I would take issue with that, Your Honor.
Go ahead,
I think that close it. I'm going to try to be very brief, Your Honor, 5 minutes. Through all of that discussion, not once did we hear any offer of good cause for the late request from Killian of an expert to come up with ash removal costs. In fact, I wrote down this statement that was just made. From the outset of this litigation, in August of 2018, the removal of ash has been at issue. If that's true, then there is no reason, therefore no good cause, to have not asserted a damage claim before November 18 of 2020. When Ms. Whittle suggests that, well, we can recover these costs under our claims for tort or negligence, that flies in the face of the court's ruling on the economic loss rule. But it still doesn't address the fact that there's been no showing of good cause. She said, well, our experts have estimated in Killian's report $100 million, and that doesn't include the cost of removal. Exactly. So why didn't you assert the cost and the claim you're asserting now in November back in January when your expert reports were due? She says specific performance and injunctive relief have always been a part of this case. I agree. But there's no money claim that has to be asserted with that, or that is. It's not required when they ask this court to fashion a judgment ultimately. Moreover, if they thought they were going to claim it, they should have claimed it within the time parameters set and ordered by this court. She says that the appealers can rely on hearsay. Well, no, they can't. They're not experts. And the fact that Jason Peeler runs some trucks and that they move dirt around on their property doesn't make them experts. And when we get to that point, I suppose we're going to be making now a Robinson challenge as to the Peelers and whether they're really experts. She says that San Miguel or their lawyers demanded that Mr. Barker withdraw his report. And that's just simply not true. But in any event, all that business about Newfields is not relevant. First, they got to show good cause and no prejudice to the defendants, and they have failed to do that. Moreover, if you look at Killian's affidavit, Your Honor, what Killian said he did was he talked to this Mr. Gobb, and he never spoke to the author of that report. So whatever that author knew, we have no reason to believe that that author knew that there was pending litigation. Finally, the last 15 minutes was spent doing sort of the magician game of, if you think we're bad, look at how bad these guys have been. They haven't produced these documents until just recently. Well, the truth of the matter is, Your Honor, A, that has to do with operations at the plant, not the mine. What we've been talking about is damages as to the mine, not the plant site. Second, this is ongoing work. It's ongoing today. And we understand our duty to seasonably or reasonably supplement our discovery, and we will. But it is not relevant to the issue that we're asking this court to rule on today, for which they have offered no excuse other than to say, oh, well, you always knew ash removal was a part of it, but they haven't asserted damages. And they didn't until all discovery was over for months and months. And we ask this court to grant the motion to strike.
In your response to the motion to strike some of your evidence as untimely disclosed?
Well, Your Honor, I would say it's not untimely, but if they want to file a motion to compel, file the motion to compel. Let me have an opportunity to look at all the rationale, what we've already produced, what we produced in the 800,000 pages that have been produced, and what's been responsive. I'm going to have to match up requests for production, what was called for, when it was called for, and what we've produced. But today is not the time for that. I need to see a motion to compel and an opportunity to respond.
But
Your
was there a
Honor.
motion to exclude built into the Peeler?
Yes, Your Honor, it's built into our response, and the motion to compel deadline passed a long time ago. So this would be more about a motion to exclude. Mr. Sutherland only recently raised this evidence in the hearing that we had on Mr. Hemingway, and I just want to make 2 points, Your Honor. Mr. Schick just said he agreed that injunctive relief and specific performance have been.
Actually, let me let Mr. Schneider and Mr. Butler have another shot if they want. So let me, Schneider.
Thank you, Your Honor. I just want to briefly say, first off, although I appreciate the Peelers acknowledging that there is obviously no breach of contract claim against Kiewit Mining Group and that we've reached an agreement and the Peelers have agreed not to seek any injunctive relief against Kiewit Mining Group. And as a result, this proposed $200 million damage model won't be sought against KMG. Nevertheless, this is important with respect to just overall practices. KMG is joining in on this motion to exclude, so to establish a precedent that the Peelers can't later on try to shoehorn in a new damage model or even new claims against KMG. That is why we've joined in on this motion to strike. And I want to point out, Your Honor, with respect to, I know Mr. Schick mentioned this briefly, but with respect, I think it was to the TRO that was discussed previously. I think Ms. Whittle said that it was at the TRO in August 2018 when these coal ash damages were first disclosed. But I also want to point out in the Peelers' own Exhibit 3, an affidavit by Mr. Killian, he acknowledges that he didn't even contact the person who provided or the company until October 29th, 2020 to get these estimates. So the reality is either they failed to timely disclose it and laid essentially behind the log of this damage model, or they simply were not preparing this damage model and didn't intend to prepare this damage model in the first place. Either way, the fault lies with the Peelers, and they have failed to provide any justification for developing a late damage model or not providing information for this damage model they claim had been around since August 2018 as a result of this extreme delay. But however, the Peelers have certainly not shown that this extreme delay has not prejudiced Kiewit Mining Group, STEC, or San Miguel, because it's obvious the Peelers' attempt to add an additional $200 million in damages after discovery, after 40 depositions, after all of the motion practices and all the other motion deadlines have passed, will either result in the parties not having an opportunity to do discovery and contest this, or will reopen Pandora's box. And that will cause KMG itself prejudice, because no matter what, even though this $200 million might not be claimed against it right now, it will have to participate in all the discovery. It will have to participate in all the motion practice just to ensure that there's no other new damage model or claim that pops up against it. And it's for these reasons, Your Honor, Kiewit Mining Group has joined this motion to strike and asked the court not to allow this coal ash removal evidence into this case, Your Honor. Thank you.
Mr. Butler?
Your Honor, I'd just jump in with Cody on that one. I didn't hear anything from opposing counsel that sought to address our concerns with particularity as to STEC, that because we had received our motion for summary judgment, that we're therefore not subject to any contract claims. And therefore, we think that, to the extent that the CAN Peelers have basically conceded that point. However, just like KMG, we too are concerned about the precedential nature of, after discovery is closed, after all the depositions have been taken, after, I don't even know how many Dalbert motions we've all had to sit through, suddenly a damage model that comes in that triples the existing damage model. I just don't know if you can get more prejudicial than that. And to say that we are prepared for this, that we should have seen this coming, you know, I know from STEC's point of view, that's just not the case. And I know that my predecessors at STEC and myself and Mr. Kirstein may have taken a different route in preparing this case. We might have filed different motions for this case had we known that this was, you know, a damage model that was sitting out there. But, you know, I just asked the court to consider, first of all, the arguments particular to STEC and how we're not subject to any of these damages, but then also just take into consideration the impassioned pleas from Bob that we're sitting here, we should be, or we were sitting here with a March trial. I know the trial date's up in the air now, but we were sitting here with a March trial date when this damage model was hoisted upon us. And so, you know, to say that that's an unfair surprise, I think is an understatement. And so we just ask that the exhibits subject to our motion and the testimony therefrom be stricken. Thank you, Your Honor.
All right, Ms. Whittle?
Yes, Your Honor. So just to be clear, this is not a new damage model. Our damage model is the same. Mr. Killian is our damages expert. Mr. Bolton testifies as to the loss of fair market value based on the restoration plan developed by Mr. Johnson and costed out by Mr. Killian. What we've done is provided what we believe is the likely cost of our requested relief for specific performance or injunctive relief. And as Mr. Schick admitted, specific performance and injunctive relief have been at issue in this case from the beginning. He also stated we didn't need to provide what those would cost and that the court wouldn't consider those. So I don't see how that translates to a duty to disclose or a failure to timely disclose. We think that this evidence is helpful in terms of demonstrating reasonableness of our damage model because it shows what it would cost to remove all of this unlawfully placed ash. And it helps the court fashion an injunctive remedy in the event that the peelers are capped at loss of fair market value and have to accept this long-term forever disposal of coal ash, which will serve as a permanent source of pollution to their property. In addition, we believe this is relevant to exemplary damages. And again, that's not something we needed to disclose what we were going to argue our exemplary damage model is based on, but we have. And also, Your Honor, I think we don't know what we don't know. You know, we couldn't file a motion to compel by the deadline because we didn't know that San Miguel had all of these additional documents from two other entities they didn't disclose prior to the motion to compel deadline. And so we've asked for the court to exclude any evidence regarding San Miguel's response action that wasn't produced prior to the expert disclosure deadline. I mean, as Mr. Schick has argued to this court, deadlines are deadlines. And so we shouldn't be prejudiced by their failure to disclose and our inability to have discovery on any of this new documentation. Thank you, Your Honor.
Right. Anything else from anyone?
Your Honor, I just have 2 points. One is with respect to specific performance and injunctive relief. Again, my point was misinterpreted by Ms. Whittle. My point was that goes to the court, not to the jury. And nothing ever needs to be said about the quantum, the cost of those things if the court believes that as a matter of law, that relief ought to be awarded. The problem is when Ms. Whittle or the peelers want to put that dollar figure in front of the jury. And if this is what they were after, they've known it from day one, there's no reason, and they haven't even attempted still to assert good cause. As to the discovery of ongoing work, I mean, Judge, it's going on today. I can't produce the document that's going to be produced tomorrow with respect to some of that work on the plant site until I've got it, until the work is done. And that's what's different about their claim about my production, late production of documents. We've produced them. We produced 530 of them, and we'll continue to as that ongoing work takes place. And again, I'll emphasize, that's work going on at the plant site, not the mine site. Thank you, Judge.
And how could I segregate or know on the documents that were just recently produced, how long you've had them or how long your client has had them?
Your Honor, some of these documents are from October 2019. The majority are from March and April 2020, and we're still missing any communications between the three separate engineering entities. If Mr. Hemingway intends to testify as to work performed by Newfields and stamped by a Newfields professional engineer, there should be some communications between them. We don't have any of that. And I don't think he's really able to testify as to what another engineer at another engineering firm actually performed. There are all of these drone videos and photographs that apparently were created in February, March, and April of last year. We don't have any of that. It seems unreasonable to suggest that the lawyers at Vincent and Elkins weren't aware of these documents or didn't consider their ongoing discovery obligations until January of 2021, given how long these documents have existed in the world.
Your Honor, part of the problem here is, as I started this, it's an ongoing project. We're draining and relining ash pond A, ash pond B, and the equalization pond. The work is not yet completed. So as Your Honor has to appreciate, there comes a point when you say, well, look, we're going to finish this project, then we'll produce all the documents. So the fact that there may be some documents that existed out there at a certain time, I'm not going to the client saying, hey, on a daily basis, send me whatever documents are created. I'm more likely to say, okay, when you finish up the ash retrofitting project that you are doing, which Ms. Whittle and others have asked questions about, when you have finished doing that, let me know and we'll need to gather up all the relevant documents and produce them. But again, Judge, I will say it has nothing to do with what is in front of you today. And if the court is concerned about it, I would much rather be given an opportunity to fully respond to it than doing it because of one sentence that's contained in the response to our motion.
All right, with regard to the appealer's motion to strike.
It's actually our, oh, I'm sorry.
Well, they have their counter motion. I will deny that, but ask the parties to confer. I understand that there's ongoing projects and there's new documents generated every day or every week, every month. But I don't think it follows that your client gets to wait for a year before they show them to the other side if they're discoverable. So I'm going to ask the parties to confer and see if you can come to a schedule for how soon they should be turned over. And if not, then I can have a hearing on that. And on the Peeler's motion to strike Donahue and the San Miguel's motion to strike the coal ash removal damages, I will grant both of them.
Thank you, Your Honor.
And ask y'all to, as the attorneys, to, if you have not already, to provide me with a draft order.
Will do. Thanks, Judge. May we be excused?
Yes.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
And Ms. Riley? Oh, yeah. Okay, so Lynn is in a